we're up and running. Welcome.
Thanks, Stephanie. My name is Debbie Shipman, as Stephanie said, and I'm going to kick it off today with our advanced IRAs. But as she said, I have Jeff Aga with me today. And so before I get started, I'm going to go ahead and ask Jeff to hop on and just say hi, so everybody can see him who hasn't seen him yet from yesterday.
Well, good morning, everyone, and welcome to Advanced IRAs. I'm glad you've all joined us today. And again, this is Advanced IRAs. So Debbie and I work with the assumption that you've got some basic knowledge on IRAs. And if you were with us yesterday with IRA Essentials, all of those do have that. So we're going to dig in some of those topics that Debbie and I covered yesterday much more deeply and address some of those things. I always like to welcome not just the topics that we are discussing today, which you find in your guidebook, but if you have any other questions, because this is the advanced course, we do welcome those and we encourage those. So the best way to ask that is, of course, to ask it live by unmuting your computer or phone, depending on how you logged in to Zoom, or you could use that chat feature as well to ask those questions. So I'm glad you've all joined us today, and I'm going to turn it back over to Debbie because we've got a lot of material we want to get covered today. So welcome, everyone.
Thanks, Steph. Before we get started with our content today, I just wanted to pull up the guidebook. You guys should all have the guidebook. We're going to go through all of the sections: legal issues, excess contributions, required minimum distributions, beneficiary options, which tends to probably get us the most questions, and that's great. And then the new IRA withholding requirements that took effect this year. After the content in your guidebook, you're going to see job aids, and it actually does start on job aids page 1, but it is right after the last content of the withholding section. But it is going to be all of the diagrams and so forth that you see in the book, and then some. After that, there's going to be a glossary as well as the exercise answers that we're going to be working through today. And as Jeff said, please feel free to unmute your phone for those answers or to send the answers through chat, whichever works best for you. But we welcome that and questions at any time. The other thing that I wanted to point out is that these books were finalized before Secure 2.0 passed. And so Jeff and I will be sprinkling some 2.0 information in there as it's relevant to the content. But I did want to show you where you can go to get more information about Secure 2.0. So if you do go out to ascensus.com, you can scroll to the news. And if you click on news, it will take you to articles here under industry and regulatory news. If you would like this sent to your mailbox, you can scroll down on that same page and just enter your email address and click subscribe, and you'll get an email for verification. But you can go ahead and click on this article here. It'll always show the most recent article, so you can always use the search feature to just like type in Secure 2.0 or whatever topic you're looking for those articles. But we did publish an article about the Secure 2.0 enhancements, kind of an overview at this point. But that is out here for you if you would like to take a look at that. So just to kind of give you a heads up where you can find some more information about Secure 2.0. So with that, we are going to start with our IRA legal issues. And we are going to go ahead and take a look at those table of contents on page number 1 with our legal issues. What we want to be able to do after this section is recognize our power of attorney or POA documents and issues, I should say. And then we also want to be able to understand the roles of what's called a guardian or a conservator involved in those IRA transactions. And we also want to identify and resolve abandoned property issues, as well as explain transactions that result from divorce or legal separation. So on page number 2 in your guidebook, we're going to start with just an overview of a reminder that when it comes to handling legal issues, you want to make sure that you're not giving tax advice. It's extremely important to answer the question from the standpoint of this is the tax law or this is the compliance information. But if they do have questions specific to their situation, they should probably talk to an attorney, their own tax preparer, depending on the scenario. And a lot of the information that we're going to be talking about, POA documents, conservator guardianship, things like that, might need to be referred to your financial organization attorney for review, or to create a process on what to do when you receive these documents. How do you verify the information, or what are the steps at your financial organization? Federal law governs IRAs, but there are a lot of state law issues that might come into play that affect IRAs. And we have a bunch of those listed on page number 2 in the bullet points. So tax law, property law, probate, trust, family, and contract law all may be state driven. And that's where your legal counsel would potentially come into play to take a look at that information at the state level and see how that might be affecting anything that those particular scenarios are involved in. So kind of keep that in mind. When we are talking about power of attorney, which is going to be the first piece that we're going to be looking at within this illegal issues section, a POA, or power of attorney, is a legal document that authorizes one individual to act on behalf of the other individual, in this case, the owner of the IRA. The person that is authorizing, the person who's in control, is going to be known as the attorney in fact, or the agent, and they're acting on behalf of the IRA owner, who is known as the principal or the grantor. So you're going to hear slightly different terminology, or read certain different terminology within that POA document, but that's really kind of what those definitions fall down to. What that principal or grantor is doing is authorizing the individual or attorney in fact the ability to act as them, or to kind of step into the shoes of the principal. So as an example, if I want to have my dad be my power of attorney on my IRA, I am going to then draft a power of attorney, or have my legal counsel draft a power of attorney. And again, we'll talk about different sample power of attorneys that can be done, as far as like how to revoke it and what you should do. But I could potentially have that drafted by my legal counsel. There might be a fillable power of attorney that the state offers through their website. So I could have that, created in a different form or fashion. What I'm doing at that point is allowing my dad, as my attorney in fact, to step into my shoes. So he would be able to transact on my IRA as if he was me. So that's kind of the role of that power of attorney from that standpoint. Now, there's 2 different types of power of attorneys, and we have a chart on page number 3 for you. The first is the durable power of attorney. That will continue even if the principal becomes legally incompetent. So if I have a durable power of attorney in play and I become legally incompetent, my dad, as my agent, as my attorney in fact, he would be able to continue acting as my POA in that situation. With the durable power of attorney, it should contain a provision that allows that POA to remain in effect upon that incapacitation of the principal, of myself. Now, it also can allow for broad authority of that attorney in fact to conduct business. So it might be specific. It can have broad authority. It's all about how that POA is drafted, what's included. The non-durable power of attorney will cease when that principal becomes legally incompetent. So if I have my dad as my power of attorney and I become legally incompetent, my dad no longer has that role of power of attorney. So it ceases at that particular point. Much like the durable power of attorney, I do have the opportunity to give him broad authority. So he can certainly do that. Now, the documents, again, can come from something that I've had my legal counsel draft. It could be something that the state offers kind of as a fillable power of attorney, usually a lot easier, definitely cheaper than having my attorney do that. But ultimately, those are ways in which I can create that power of attorney. And then the difference between the durable and the non-durable power of attorney. Now, while the durable power of attorney can continue upon my incapacitation and the non-durable power of attorney doesn't, while I am competent, do have the opportunity to revoke the power of attorney at any point in time. So taking a look at page number 4, if I choose to revoke the power of attorney by choice, because maybe my dad's passed away, and so I no longer obviously want him to be listed as my POA. Maybe I want to set up a new POA with a new attorney. In fact, maybe I no longer want my dad to hold that role simply because we've had a falling out and I no longer want him to have control over my assets. So it really doesn't matter why I want to revoke that POA, but I can certainly do that. It's completely my discretion to do that revocation. Now, there are various different state laws that the POA can revoke in different manners, but they might be able to revoke in writing by a simple act of destroying and destructing that, a presumption of the revocation of the POA, or verbally. From a documentation standpoint, it's always probably easier for you to have that in writing so that you know that that's been revoked, but that's going to be kind of your discretion, your business policy on how that should be received at your financial organization. And of course, it does need to follow state law. And that's where your legal counsel would come into play as far as what your state law allows. I need to notify my attorney, in fact, my dad in this situation, that I am revoking that power of attorney as well. So again, it's a good idea to have that written instruction. So you've got the documentation, not only that I revoked that with my dad and he is aware of that information, but I've also provided it to the revocation paperwork to the financial organization so that you have that information as well. When we are looking at the overall revocation process, I should be giving notice to the financial organization, to my attorney, in fact, and making sure that any institution that I've given that power of attorney authorization for, could be a financial, could be medical. I do want to make sure that I've notified them as well of that revocation process. And I should also collect and destroy any of the POA paperwork. I do want to show you a sample revocation form on the bottom of page 4. It doesn't have to be anything fancy, but it's simply something that can be done. We would recommend that it be notarized so that you can then provide it, the principal can then provide it to the financial organizations, to the medical team, for example, the hospitals, the doctor's offices, but that way it's notarized so that it should cover all of the requirements for all of those different organizations. But it basically just says, I'm no longer authorizing this individual to be my POA as of this particular date. So it doesn't have to be anything, super fancy. Now, as far as the financial organization is concerned, when you receive the POA paperwork, what are you actually looking for? And again, what you want to take a look at is what has your legal counsel set into play as far as the process that you're going to follow at your financial organization. It may be that you receive power of attorney paperwork and it goes directly to your legal team and they do all of the review process and verification to make sure that everything, all the T's are crossed and the I's are dotted. There may be a process that once a financial organization receives the POA document, that they go ahead and start that process, and then maybe the legal counsel steps in at a certain point, or maybe it can be verified by the financial organization without going through their legal counsel. So that's a business decision, and that's going to be set up by your organization, working with your legal counsel to determine what your process is going to be. But ultimately, to determine if the POA document is valid, you want to make sure that you're looking at signatures, scope, documentation, and any outside concerns that might exist. So from a signature standpoint, on page number 5, in the first subheading, if you will, and series of bullets, you want to make sure that the POA document is in writing, that it clearly identifies the principal and the attorney in fact, that it's signed and dated, and that it meets any state-specific requirements. Again, that's where your legal counsel will probably have a policy set in place for you as far as what do we do once we receive this. Within the scope, what you are looking for is what can this POA, this agent, or excuse me, attorney in fact do? What are they allowed to do within this POA document? For example, when I actually did set my dad up for a power of attorney on myself, it was for a specific thing. It was to sign on my behalf when we closed on our home, because I happened to be traveling for work on the date of the home closure. So I missed out on the opportunity of signing my initials in 3,472 different spots on all of that paperwork. But my husband did, he got that fun, and so did my dad, because my dad was given POA on that one option, that one piece of information, that because the scope of that POA document only allowed him to do that, that didn't give him the authority to act on my checking, my savings, my IRAs, any of my medical information. It was narrow in scope. So within the scope of the document, you're going to be looking for what does this attorney in fact have the capability of doing. You're also going to be looking as to whether it's durable or non-durable. Again, durable will continue after the principal's incapacitation, where non-durable ends. So you're kind of looking for that information. You're also looking for, when does it become effective? Does it become effective immediately? Is it down the road? They're planning ahead for potentially, let's say, a vacation that they're having, and they want somebody to have control while they're gone. And does it expire at a particular point, or is there no expiration date just upon the incapacitation or the death of the principal? Again, going back to my situation, I specifically had an effective date from the point that I was leaving through the point that I was coming home from my trip, even though I knew that the home closure was going to be a specific date. In case it got pushed out to a different date and I was still gone, I wanted my dad to have that capability. So I specifically had an effective beginning and an expiration date listed in mine. Again, not for IRA purposes, but you kind of get the idea of how that POA worked in my situation. From a documentation standpoint, you also want to make sure that you're retaining a copy of the POA document on file, in the owner's file, and that you have received identification from the attorney in fact prior to authorizing any transactions. So if the attorney in fact isn't there at that particular point in time, before anything is allowed for them to do any transaction, conduct any business, you do want to make sure that you have gone through your verification of identity process, whatever you have set up at your financial organization, to identify who my dad is, and because maybe he's not a client of yours normally, so you want to make sure that you do get that information, that you know that's the individual that you are in fact working with. As far as any outside concerns that you want to take a look at, you do want to make sure that you've reviewed state law. Some state laws have protections for the financial organization that acts upon the POA that does appear to be valid. So again, it's important that you're going through verifying the signatures, verifying the scope, getting a copy of the documentation and identification, so that you can say, you know what, we followed the rules that were within this. And some states, again, provide protection for organizations that do that. As I mentioned, depending on your process and policy at your financial organization, you may need to have your legal counsel review that POA paperwork. There may be a special process that you have to follow compared to you verifying this information. It may all be done in-house through your legal counsel. Does the document provide for multiple attorneys in fact? And if that is so, both, let's say my dad and my brother can act on my behalf. They're both attorneys in fact on my POA document. You would want to again verify identification of both individuals. Can either one transact independently as part of that document paperwork? Do they need to both agree and sign on that document for that transaction? So depending on what that document states, if there's multiple attorneys in fact, you might run into those scenarios. And again, because the attorney, in fact, is really, as I said, stepping into the shoes of the principal or acting as that individual for these transactions, you do want to follow their instructions as if they were the IRA owner. So on page 6, we have kind of an open-ended question, and this is something that you can kind of jot down for yourself on page number 6. But what is the process for handling a power of attorney document at your financial organization? So if you know what that process is, take a moment to jot that down. If you're unfamiliar with what your process is, mark the page and come back to it when you are back in the office in your work environment. Find out what your POA document process is. What do you do? I'm popping up right now just kind of some answers may vary scenarios, but here's some things to kind of keep in mind, and feel free to jot this down if you like as well. Make sure that you are obtaining a copy of that POA document, that you're having the organization review the POA document, or you're following a process that has already been predetermined for you, and that you are then following the attorney in fact's instructions as if the POA was the one in front of you. And that's assuming that the POA is in fact valid. So you need to verify the validity of that, either through yourself or through your legal counsel, depending on your process. So while you are jotting anything down that you want to take a look at or what your process is, any questions on POAs before we look at guardians and conservatorships? Again, feel free to unmute your phone or to send anything through chat. Okay, I'm not hearing anything and I'm not seeing anything, so I'm going to go ahead and move us over to page number 7, and we're going to talk about guardianship and conservatorship. So similar to a power of attorney, a guardian or conservator would be the one who is controlling, in this case, acting on behalf of the IRA owner, the individual. Now, it's called a guardian or a conservator because it's appointed by the court. The power of attorney is something that the individual, while competent, is naming. They're choosing to do this. And again, it might continue, durable versus non-durable power of attorney may continue after incapacitation, but it is established or put into effect while that individual is competent. The guardian and the conservator are both appointed by the court. So this would be after the individual has been determined to be incapacitated. So the court is going to appoint a guardian or a conservator. The difference between the guardian and the conservator is that the guardian usually has broader powers than the conservator. The conservator is going to have less than full control, and that's going to be determined by the court. So in all cases, both of these, again, are appointed by the court. It's after the individual has been ruled to be incapacitated. The court is going to outline what the powers are of that guardian or that conservator. And again, the court can limit what powers that individual may have, whether it's a guardian or a conservator, but the guardian is going to potentially have more control than the conservator. The conservator is granted less than full control. Basic differences between those two. Now, when we are looking at the overall difference between the power of attorney versus the conservator or guardian, I do kind of have a walkthrough chart for you on the bottom of page number 7. And as I mentioned with the power of attorney, this is going to be during the owner's lifetime, as is the guardian or the conservatorship. So both of those, or all three of those, I guess, if you want to look at it that way, are all going to be effective during the owner's lifetime. But as I mentioned, with the power of attorney, it is begun while they are competent, and it can continue if it's durable while they are no longer competent, once they've become incapacitated. With the non-durable power of attorney, that will cease at incapacitation. When the mental status on the conservator or the guardianship side, the mental status of the individual is going to be incapacitated. So this does not begin, or it's not appointed by the court until after that individual has been determined to be incapacitated. With the scope, as far as who determines what the scope is, as far as what that individual POA, guardian, or conservator can do, on the POA side, that is the individual, that is the principal who determines that. Whereas on the guardian or the conservator side, again, the court is the one who's determining the scope of authority of the guardian or the conservator. How long that does continue for a power of attorney, the individual will define that. Again, durable will continue once the individual has become incapacitated. Non-durable will end at that point in time. And then the principal can also revoke that at any point in time. As far as duration, they could also set an expiration date. So if it's only for a period of time. So the individual is going to determine that when they set up that POA. With the guardian or the conservatorship, the court is going to determine how long that may be in effect. And again, who creates the power on the POA side, as I mentioned, that is the individual or the principal, but on the guardian or conservator side, that is going to be the court who makes that determination. So when we're looking at page number 8, as far as the organization responsibilities, when it comes to the guardianship or the conservatorship, you are very similarly to the power of attorney process. You are going to make sure that you're obtaining that information from the court. So you're going to get that court order that appoints the guardian or the conservator who's going to be controlling that information. Keep in mind, from the process standpoint, you want to have your legal counsel review that documentation, or you're going to have that process that's already been put in place and you're going to follow those steps. So it'll be very similar to that standpoint. So that's number 1. And number 2 on page number 8 is to make sure that you are receiving a copy of the order that appoints that individual as the guardian or the conservator. And again, getting that identification, very similar to the process from a POA standpoint. And then number 2, either reviewing that process that has been put in place for you by your legal counsel, or sending that documentation to your legal counsel for review and approval once it's been valid. So that's kind of what you're looking at. Questions at all on the conservator or the guardianship? Not too much different than the POA as far as your responsibilities, but obviously what they, not necessarily what they do, but how they're created is going to be different. Okay, so we are going to take a look next at a sheet, and this is probably where I would say of all of these topics, this and divorce are probably 2 of the topics that I get questions on more often than not on the phones. Jeff would probably, I would say, tend to agree with me on that, just based on my experience. I would say his is probably very similar, but his sheet tends to come up with a number of questions as well. What do we do with the IRA funds when they've been abandoned or they're not claimed? So sheet laws within the United States grant the individual states rights to kind of set that rule and process and kind of dictate how that functions. So they could be different from state to state. So kind of keep that in mind, that while Michigan may follow this set of rules, Wisconsin, where I live, might be slightly different, but most states have very similar requirements, is what we have found. And basically what a sheet is doing is handling any unclaimed or abandoned IRAs, or potentially any other types of property, but specifically talking about IRAs today. What you want to do as a financial organization is to make sure that you are identifying what your state law rules are for a sheet, because again, they can be different from state to state. So you do want to kind of make sure that you're following that information. The first thing that you want to do from identifying abandoned IRAs is, as I said, determine any relevant state law. And this is where your legal counsel may come into play to determine what state law may be overarching on the escheat rules. Now, escheat rules are generally applied at an individual level and not at an account level. So the IRA in kind of by default, if you will, a lot of folks are, contributing to it during their working years. And then they're not contributing to it when they retire. And maybe they don't even have to start required minimum distributions yet because they're not yet of age. And so it sits there and it doesn't do anything other than gain interest. So there's no contributions coming in, there's no rollovers or transfers coming in, there's no distributions coming out by choice or mandatorily. And so if it was applied at the IRA level, it would be, or just at the account level, the IRA would be very susceptible to escheatment because it's very possible that it could sit there for a number of years with no activity. Because most escheatment laws are applied at the individual level, if I have another account with you besides my IRA and that one is active and I'm having activity on that one that keeps it alive, if you will, it usually does then reach over to all of my other accounts and it keeps my IRA from being escheated during that same time frame. So while there may not be activity on my IRA, activity on my other accounts that I have at that financial organization may, cross over, if you will, to the IRA and keep it from being escheated. Now, within the Uniform Unclaimed Property Act, Section 2, which is in the first paragraph underneath identified abandoned IRAs on page 9, that provides guidance for IRAs or other deposits that are there at the financial organization and that are presumed to be abandoned. So if you need to refer back to information, you can certainly look at the Uniform Unclaimed Property Act in Section 2, or maybe again, your legal counsel is doing that on your behalf. But ultimately, that's where we're kind of coming from with the information. And most states have enacted a version of that Uniform Unclaimed Property Act. So generally speaking, accounts and again, this is usually at the individual level and not necessarily at the account level, but in general, it is going to be 3 years. Some states are 5, some states are 7, but in general, it's usually 3 is what we have found, where there's no activity, and that's when escheatment would begin from that standpoint. So that's generally, it can be different, as I said in the first bullet point on page 9. Yes, first bullet point. From state to state, again, it can be different. Most are 3. We've seen 5. I've heard of 7. 3 and 5 tend to be the most common from what I've personally run into. Some states also don't start the escheatment process until there's no activity after the owner would have reached RMD age. And that's again how the state is drafted. So now that age is 73, we're going to talk about that in our RMD section a little bit later this morning. So usually, let's say 3 years from then, or 5 years from then, or 7 years from then is when the escheatment process would potentially begin. So that's kind of what we're looking at. Oh, excuse me, I clicked one too many times there. Roth doesn't have an RMD. So while this is kind of sometimes, again, not all, but some states base this on the point from the RMD age and then 3, 5, 7 years out. Even though there's no RMD in a Roth, we have found that a lot of states follow the same rules for Roth IRAs as well. As far as locating missing owners, you want to make sure that you are attempting to contact them before the escheatment process begins. So you do an attempt to contact them, and then you're going to go ahead and, assuming that's come back with no contact, you're going to go ahead and report those accounts that are presumed to be abandoned to your state. And that is something that is required by the Act. So it's important to do that. When you are on page 10, paying out and reporting the information to the state is, this is the bottom of page 9, top of page 10, financial organization will also then reach out to the individual and attempt to contact them. So that is the second attempt to contact. And then the state will also publish the notice in the second attempt, rather, is the state will publish the notice in the paper. If you've ever noticed in the paper, there's all of those attempts to contact. And then the state in the third attempt will also mail a notice to the IRA owner at their last known address. So they are getting 3 attempts of notification between the financial organization, the state, and the state twice, excuse me, I'm trying to count. So we've got three, but financial organization, state notification, state mailing, three. And so again, that's the bottom of page 9, top of page 10. When on page 10, the state, you as a financial organization are paying those funds out to the state, you are going to deliver those within 6 months from that time frame. So you're looking at the dates that I have in here. Let's see, I'm going to find it. Everything you do through July, you notify within 6 months. The act, second paragraph on the page. It's right underneath paying unclaimed IRAs to the state. So the act states that within 6 months after the final date of filing the report, which everything that you do has been abandoned through June is what you're going to be sending out. Excuse me. You are then going to send that out to the state. You are going to then complete a withdrawal statement on the signature line. You could do a sheeted to the state, you know, per the requirements, whatever you want from that standpoint, so that you kind of know what happened to those assets. We will talk about reporting in just a moment, but you're going to report it as a probably normal distribution, because it's probably going to be an older individual who's over 59 and a half, but you're going to use your standard codes for reporting. And then from that point, you have gone ahead and paid it out to the state. As far as reporting goes, as I mentioned, this comes from IRS Revenue Ruling 2018-17. That addresses how that is reported to the state. It did not, however, address beneficiaries. So if there is a beneficiary where they've inherited assets and those are now being escheated, because Revenue Ruling 2018-17 did not address that, excuse me, we would recommend that you report that as a beneficiary distribution and use the death distribution. So that's going to be either a code 4 on the traditional beneficiary side, or a T or a Q on the Roth side, depending on whether or not it's the beneficiary has met the 5-year rule as part of the deceased owner scenario. In this case, however, withholding rules apply. So if you do not have an election for withholding on the system from that individual, you do have to mandatorily withhold 10%. The revenue ruling doesn't indicate that the state can waive the election of the withholding, so you would want to follow those withholding rules. Now, the example that I have for us on page 11 talks about the reporting process, just to give you kind of a visual of how this works. So Barbara is 78, and she has a traditional IRA with us. She died June 12th of 2016. Her brother, Brian Carlson, is the beneficiary of her IRA, but he has not made an election to receive the assets. State law allows you to escheat the assets to the state. So Barbara's traditional IRA is currently has a balance of $83,984.25. This is how you're going to report that to the IRS, excuse me. So it's going to go out in the beneficiary's name. So you're going to see this is now in Brian Carlson's name, Brian's social security number. If you do not have Brian's social security number, then at that particular point, you want to leave that box blank. That is on the bottom of page 10. If you do need to see where that is written. But if you do have Brian's social, you will enter that. So blank if you don't have it, fill it in if you do have it. You are then going to go ahead, and if you want to fill in page 11 with me on the screen, feel free to do so. Box number 1 will show the gross distribution, and that is going to be the full value of the IRA that you're escheating. Box number 2A, in this case, because it is a traditional, will match. Box number 2B will be marked taxable amount not determined, as well as total distribution. Box number 4 will have the federal withholding, because there was no election, we have to default to 10%. And because it was a death distribution with the traditional, we will use code 4. Because it's a traditional, we will also mark the IRA separate simple box. So this is what the escheatment would look like for the 1099-R. Questions on escheatment that you have at all? Okay, so we're going to take a look at divorce and legal separation. So taking a look at page 13, it is possible in a divorce of a couple that one individual has to give the other individual, the former spouse, a portion or all of their IRA. So IRAs are going to be subject to that overall property division. What you want to do is follow the legal document for how those assets are to be moved. Now, that document may not specifically designate how to move those monies. It may allow for a transfer. If it's unclear, you may have a policy or your legal counsel may need to review it and then send it back to the court for more clear instruction on how to divvy up those assets. Transfers are the general method for moving assets from an IRA owner to their former spouse. The transfer is non-reportable. It avoids taxation and any possible penalties that are out there. You do need a written instrument directing that transfer. That could be, again, the court order, the divorce decree information that you've received. Ultimately, you want to make sure that you're following that. In that case, you would then go ahead and take the money out of the IRA owner's account. You would transfer it either internally to the former spouse's IRA of the same type, or you would then transfer it externally, making the check payable to the other financial organization for benefit of the former spouse. And then it would be a transfer non-reportable. With rollovers, there's no written IRA guidance that allows for a rollover. So it's a business decision from the financial organization standpoint on if they're going to allow that distribution and then subsequent rollover. You do, however, need to obtain, a signed statement from the recipient allowing that, because it is going to be reported and it is potentially taxable if all of the money is not rolled over accordingly. It is subject to the 60-day rule. So if they don't roll it over within 60 days, it is, again, subject to income taxes. And it is also subject to the 10% early distribution penalty tax. So the signed statement could be, hold harmless agreement that we're going to allow this rollover, but we're not going to be responsible as a financial organization if they have any adverse effects from a taxation or penalty standpoint. When a distribution is done, if it is distributed directly, so it's not transferred, but it's just distributed directly on page 14 rather, to the former spouse, it's coming out of the owner's IRA, it's being distributed to the former spouse, it would be reported as a distribution to the former spouse. So if Patrick and I are getting divorced, I am the IRA owner, Patrick is the former spouse, and he is receiving a portion of my IRA as a result of that, and it's being done as a distribution and rollover, it would be reported in Patrick's name and social security number as a distribution, as well as the subsequent rollover would be in Patrick's name and Patrick's social security number. So if it's done that way, again, it would be all in the former spouse's name. This is where that hold harmless would be helpful, so that if Patrick has any adverse effects from a taxation or penalty standpoint, then he can't come back to the financial organization and say, hey, you should have done it this other way, and now I'm subject to income taxes and the income taxes and the early distribution penalty tax, So keep in mind with that information, not only would there be reporting for my husband, in that case, the former spouse, but you would also want him to fill out a withdrawal form so that you have that documentation as to what the situation is. If you do use the census's forms, on our withdrawal form, this would be part number 3. Part number 3 is used for beneficiary distributions by a beneficiary or for a divorce situation as well. The former spouse would then fill out part 3. I would be part 1, the IRA owner, Patrick would be part 3, the former spouse, if you use the census's forms. If you're not using a census's forms, you do want to check with your forms provider to see how that would be documented on your withdrawal form. Now, when we are talking on page 15 about quadros or qualified domestic relations orders, those by definition only apply to certain employer-sponsored retirement plans, not to IRAs, but you may hear it, you may run into it, but ultimately what a quadro is doing, It's allowing that former spouse to roll over, retirement plan distribution assets to an IRA or to an eligible plan that they have in their name. What you want to do if you're receiving information is to verify that individual is the former spouse of the actual employer participant, and then you want to go ahead and complete the rollover. In this case, it's coming from a plan, so it would be a direct or an indirect rollover. And you want to go ahead and complete that contribution form, that eligibility form, a hold harmless statement, to verify that we have no bearing on this information, but ultimately we're following the instructions of the former spouse at this particular point. So that is our quadros, and that wraps up our IRA legal issues section. Before I hand it over to Jeff to start our IRA excess contribution section, any questions on anything that we looked at in our legal issues section? Again, feel free to unmute your phone or to send it through chat. And if anything comes up later, don't hesitate to bring it back, and we're happy to answer it at any particular time, regardless of who was training at that point. Okay, I'm not hearing anything or seeing anything. So Jeff, I'm going to pass it off to you.
Okay, thank you, Debbie. And again, good morning, everyone. Next, we're going to talk about IRA excess contributions. So on page 17 in your guidebook, let's take a look at our learning objectives. So what we'll first do is we're going to define what an excess contribution is, and we're going to then look at when we have an excess, what are some of the ways that we can correct these excess contributions. So we're going to identify excess contribution methods. One of those methods is called a recharacterization. We will describe what a recharacterization is. We'll also explain the possible tax as well as penalty taxes that could come about due to excess contributions. And we'll also describe the reporting requirements for these excess contributions and recharacterizations. So let's take a look at what is an excess contribution. Well, anyone who meets the eligibility requirements to contribute to a traditional or Roth IRA can make those contributions. IRA owners might be ineligible to make a contribution based on these requirements, or they possibly could also change their mind. So when we talk about excess contributions, they can really come about due to a number of different situations for the IRA owner. So really, if we look at it, how can we get an excess contribution? Well, there's really a few ways that we can have that. Maybe due to funding it through a regular contribution, or maybe a rollover potentially could do it. But they can really occur anytime the IRA is funded. There's two types of excesses that we could have. We could have a true excess or a deemed excess. So true excesses, that means we're not following the rules, okay, for who can contribute to IRAs or how we are funding that. So those really have to be corrected. A deemed excess, well, that's okay. We were eligible to make the contribution, but we just changed our mind. So I sometimes refer to a deemed excess as, oh, changed my mind, decided didn't want to do that. So let's take a look at what causes, first of all, a true excess. So if we have a true excess, that really comes about if the IRA owner really isn't following the rules for making contributions into their IRA. So it really doesn't belong in the IRA. How do they do that? Well, for traditional IRAs, maybe they exceed the individual contribution limit. So for this year, instead of the $6,500 regular contribution, someone 40 years old puts in $7,500. not understanding the rules. So that can create a true excess. Or maybe they exceed their eligible compensation limit. Yesterday, we talked about who can contribute to IRAs, and Debbie mentioned one of the things you have to have is eligible compensation. And when we look at the contribution limit for this year, say $6,500, it's the lesser of the eligible compensation, typically for working for someone that someone earns, or $6,500. So somebody maybe only earned $4,000, but they made a $6,500 contribution. Well, that causes a true excess to their traditional IRA because they did not have eligible compensation. That could come true with Roth IRAs as well. So if they exceed the individual limit or they did not have enough eligible compensation and we make a contribution to a Roth IRA, that can cause a true excess as well. So instead of the traditional IRA, they only earned $4,000, but they put $6,500 in their Roth IRA. Well, they still didn't have enough eligible compensation to make that full contribution. Now with Roth IRAs, the other way that we can have a true excess is maybe their compensation exceeds the modified adjusted gross income limit for making those contributions. So that's another way with Roth IRAs that we could also have a true excess. So really we exceeded our limit. We weren't eligible to make a contribution, or another way would be maybe we had an invalid rollover amount, such as an RMD that should not have been rolled over, or we exceeded our 60-day rollover period. So not just our regular contributions, but maybe with rollovers, we created an excess because we weren't following our rollover rules when we funded our IRA with a rollover contribution. So that's another possible way that we could have true excesses as well. So for Roth IRAs, recall that we have contribution limits. These are the modified adjusted gross contribution limits for contributing to a Roth IRA. And again, those have gone up for 2023. So yesterday we discussed who is eligible to make that Roth contribution. So as long as we have eligible compensation or earned income from working for someone, we can make that contribution. However, the law limits how much we can contribute to the Roth IRA when our income gets too high. And what type of income are we talking about? Well, it's our adjusted gross income, which gets modified and we add back certain deductions. So it's based on a modified adjusted gross income limit. So a single individual that has modified adjusted gross income of $138,000 or less is eligible to make that full Roth contribution. For this year, $6,500, or if they're 70 or older, or I mean 50 or older, pardon me, they can make a $7,500 contribution when they include the catch-up contribution. So they can make the full contribution. Now, once they exceed that $138,000 for a single individual, or married couples filing jointly, $218,000, then we start phasing out how much they can contribute to a Roth IRA. And if it falls between this lower threshold to our upper threshold, $153,000 for single filers and $228,000 for those married filing jointly, we're only able to make a partial contribution. So we can't make the full $6,500 contribution. It phases out. So the higher the income within this range goes, the less of a Roth contribution it can be made into the Roth IRA. So when they fall in the middle, they can only make a partial contribution to a Roth IRA. Married couples that file separate, they phase out right away and can only make partial contributions if their modified adjusted gross income is below $10,000. If it's above these upper thresholds that we see on the right, they make too much money, their income's too high, and the law does not permit them to make any contributions into their Roth IRA. So if they earned $240,000 and they're a married couple, and that's what their modified adjusted gross income is for the year when they look at their taxes, well, they've earned too much money and are not eligible. So if they put a $6,500 contribution into their Roth IRA, they now have a true excess. So for Roth eligibility, we have to look at that and what their modified adjusted gross income is. And if it's too high, that causes a true excess in the Roth IRA. So those are how we can get a true excess. Any questions on our true excess? Any questions? So remember, this is when we really violate any of our rules for being able to make the contribution into the IRA. Okay, let's look at what is a deemed excess then. Well, a deemed excess is simply where somebody wants to make a contribution and then they later on rethink it and they decide, oh, maybe I shouldn't have done that. Okay, so it's a valid contribution when we think about it. They just simply changed their mind for wanting to make that contribution. Maybe they can no longer afford to make that contribution, or they've determined that maybe that's not what they should have done. So when we look at our true excess or our deemed excesses, it's simply an unwanted contribution. Maybe they contributed to the traditional IRA, they put $6,500 in. They were participating in their 401k plan at work. And because of that, they found out when they talked to their tax advisor, they don't get the deduction. So it would have to be claimed as a non-deductible contribution. Well, maybe they decided since they don't get that tax benefit of taking the deduction when they contribute to their traditional IRA, well, then they can decide, well, maybe I should just take that out. Since I don't get the deduction, why should I fund it? So that could be where they have a deemed excess. So that's one of the reasons. Or maybe they contributed to their Roth IRA and they all of a sudden had some bills that came up and they need to get the money out right away to pay those bills. Well, they've put the $6,500 into their Roth IRA. Now they know they still have those funds, they can pull that out as a deemed excess. So a deemed excess really can occur when they make their regular or catch-up contribution that was eligible to be made as a deemed excess contribution. Now, if they're going to do it, they have to actually take care of it and remove that before their tax return due date plus extensions. So once they hit their tax deadline plus extensions, the IRA owner cannot remove that unless it's an excess, unless it's a true excess. And we're going to talk a little bit more about that. So true excesses, we violated the rules for funding it. Deemed excesses are, we were eligible to make that contribution, but we just simply changed our mind and decided not to make that contribution. So let's take a look at, we've got a couple of questions here on page 21. We'll give you an opportunity to chat what you think the answer is. So our first question is, we have Lisa Casper. Lisa is age 40. She is eligible, she has eligible compensation of $2,500. She made $6,000 Roth contribution on May 12th of 2022. She just told her tax advisor that she didn't have enough compensation and she would like to remove the extra $3,500. So what type of excess contribution does Lisa have? Chat your answer in. Or if you want to, you go ahead and unmute and you can answer as well. So her eligible compensation was $2,500, but she put $6,000 into that Roth. What type of excess does she have? I see a couple answers coming in. Amy and Mary, yes, very good. Yeah, Lisa has a true excess, and she told her advisor that she didn't have enough compensation. So because she did not have enough compensation, it's a true excess. So if we look at that, she put in $6,000 into her Roth, but she only had eligible compensation for that year of 2022 of $2,500. So she has a true excess of $3,500. Okay. Let's look at our next example. We've got Ben Hawthorne. Ben's age 63. In 2023, he has $18,000 in eligible compensation from working part-time at a local supply store. And his modified adjusted gross income is $41,000. He made a $7,500 traditional IRA contribution on May 25th, 2023. So for Ben, what type of excess does Ben have? Chat that answer in. How about Ben? He's age 63, single. He has $18,000 of eligible compensation. His modified adjusted gross income's $41,000, and he made a $7,500 contribution in 2023 on May 25th. What type of excess does Ben have? What type? Chat that answer in. What type of excess, if he wants to remove that, does Ben have? For Ben, this is going to be a deemed excess because he's eligible, he's working, he's got $18,000 in eligible compensation. Ben is age 63, so he's catch-up eligible. He can make the $6,500 contribution for 2023 plus the $1,000 catch-up for a total of $7,500. So he's eligible to make that contribution. So if he decides that he wants to remove that, it's simply a deemed excess. In other words, an unwanted contribution. Any questions on true versus deemed excesses? Any questions on that? Now, the nice thing about that is it's ultimately up to the traditional IRA or Roth IRA owner to determine if they've exceeded this. Your bank doesn't have to know whether or not they have eligible compensation or not, how much they earn. That really falls on the shoulders of the IRA owner as the taxpayer. So when you get these excess contributions, they'll come into your bank and let you know that they're going to be removing it as an excess contribution. Okay, now the deadline to correct an excess contribution is going to be their tax deadline. Generally, that's April 15th, plus extensions. And if someone files for an extension, they get 6 months generally to file their income taxes. So if they want to remove an excess contribution timely, they have until their tax deadline plus extensions to do that. If they timely file their taxes by April 15th, for this year, the 2022 tax year, because that falls on a weekend, we actually have until April 18th to do our taxes. So that deadline is actually for 2022 going to be April 18th. So we have that time period to correct an excess contribution. If they timely file by that, they get an automatic 6-month extension all the way out to October 15th. So for most taxpayers, the deadline to correct an excess contribution will be October 15th, following the year in which that tax year the contribution was made. And if October 15th falls on a Saturday, Sunday, or legal holiday, the deadline is going to be the next business day for those who file for an extension or take advantage of the automatic 6-month extensions. Now, we can remove that excess, or another way to correct that is recharacterize that. So we're going to talk about recharacterizations as well and how we can do that. So that's another way to do that. Now, if we correct it by the deadline plus extensions, we remove the contribution along with what's referred to as the net income attributable. So we're going to talk about that as well. So the deadline is going to be their tax deadline plus extensions. So we can take it out as an excess contribution, take a withdrawal, or we can recharacterize it. What is a recharacterization? Well, a recharacterization is simply moving it from one IRA to another type. So if they recharacterize a traditional IRA, they're going to move it over into the Roth IRA as a recharacterized contribution. Or maybe they made it into a Roth IRA and changed their mind. They can recharacterize that original Roth contribution and move that over into the traditional IRA. So we'll look at that as well for how we can do that. So the deadline is April 15th. For 2022, that original deadline actually will be April 18th. If they file for an extension or timely file their taxes, they will have until October 15th of 2023 to correct and remove an excess contribution. So if it's a deemed excess, this will be the deadline to remove it. If it's a true excess, those can be removed after the deadline. We'll talk more about that as well. So on page 23, let's go back to Lisa. She's age 40, she's single. Her eligible compensation was $2,500, but she put $6,000 into a Roth IRA on May 12th. So what is the deadline for Lisa to remove that excess contribution or recharacterize that to a traditional IRA? Chat your answer in. What is going to be Lisa's deadline to remove the excess contribution or recharacterize that? We'll assume that Lisa's timely filed her taxes. What will her deadline be? So she can choose to take that $3,500 and recharacterize that or remove it. And the deadline for Lisa will be October 15th of 2023. Okay. Now, let's take a look at Ben again. Let's revisit Ben's situation. Ben, again, is age 63. He's single. In 2023, he had $18,000 in eligible compensation from working part-time at a local supply store, and his modified adjusted gross income is $41,000. So he made a $7,500 traditional IRA contribution on May 5th of 2023. So what is Ben's deadline to remove or recharacterize that 2023 contribution? What will his deadline be? He made that contribution for this year. Chat your answer in for what his deadline will be. What is Ben's deadline? It's a 2023 contribution. So how long will he have to fix this? For Ben, he will have until, assuming he's either filed for an extension or timely filed, he will have until October 15th of 2024. Recall that this is a 2023 contribution that he put in for his traditional IRA on May 25th. So it's for the 2023 tax year. So he will have all the way out till October 15th of 2024 to either recharacterize the contribution, or he could also remove that as an excess. Any questions on the deadline? Any questions on the deadline? Okay. Now, again, as I mentioned, Ben is going to have to tell you that he's got that excess, or Lisa would have to tell you that it has an excess, but you will have the records for which contribution that they made that for. So knowing the deadlines, they have generally out to October 15th of that next year to do that. So if we look at page 24, how can we correct this? Well, if the correction method depends on whether they are correcting their excess contribution before that deadline of generally October 15th of the next year, or after the deadline. So the timing really is going to be dependent on when they are actually correcting this. So if it's before our October 15th deadline, they can remove any contribution, true excess or deemed excess, along with the NIA. NIA stands for net income attributable. And what that really is the earnings that are in that IRA that are associated with that contribution. So when we remove that, the IRS says we have to pull out those earnings that are associated with that excess contribution, because the growth on that money, because we're not leaving that excess contribution in there, should not stay in there either. So we're going to talk about net income attributable and take a look at that NIA, and that should be removed as well. So that's really just simply the earnings associated with the excess. If it's before the deadline, they can change their mind and recharacterize that if they're eligible for the recharacterization to the other IRA. So let's say they made a contribution into their Roth IRA. They found out they earned way too much money and weren't eligible to do that. Well, we don't have any income restrictions for contributing to a traditional IRA. So if they want to leave their contribution in a retirement account, they're not eligible to have it in the Roth IRA, they can recharacterize that contribution and treat it as a contribution in the traditional IRA. So a recharacterization is moving the regular contribution from one IRA, in my example, the Roth, over to the traditional. Or maybe they put it in their traditional IRA and found out they didn't get the tax deduction. Well, another way to correct that is to move that traditional IRA contribution over to the Roth IRA. So when we do a recharacterization, we move that contribution of $6,500, for instance, over to the other IRA. Now, the earnings that grew in that first IRA should not stay with that. So when we do a recharacterization, we are going to move the net income attributable along with the contribution from one IRA over to the other. So as long as we're doing the correction before the deadline, we have to determine what that net income attributable is. Okay, now, once we hit October 15th, and it's after that deadline, then if it's a deemed excess, it has to remain in as a annual contribution. Deemed excesses are not permitted to be removed. It remains as an annual contribution. For a traditional IRA, it may be deductible or non-deductible, depending on what their situation as an active participant is and where their modified adjusted gross income is. So deemed excesses have to stay in the IRA. We can't fix them after the deadline. If it's a true excess, then the two ways to correct that is to remove just the excess contribution, okay? Or they can carry it forward and just leave it in that IRA and redesignate it as a contribution for that next year. So that is one of the ways that they can correct it, by carrying that forward. So we're going to talk about these two methods on how we correct that. So let's start with what's on the left and take a look at excess corrections before the deadline. Okay. Now, individuals must use an IRS approved formula to determine what that net income attributable is when they're removing an excess contribution before the deadline, or when they are recharacterizing a contribution from a traditional to a Roth, or a Roth to a traditional. So under this method, we're looking at the time right when the contribution was actually contributed and ending with the date that it's being removed or recharacterized. So we're going to calculate the total earnings during that period. Then once we know what those total earnings is, then we determine how much of those total earnings are really attributable to those to the actual contribution that we're removing as an excess or recharacterizing. So when we take a look at that, we're going to calculate the net income attributable for that contribution. When we do the calculation, we're going to calculate it on the IRA that contains the excess. So once we determine what that net income attributable is, if the net income attributable is being removed, well, then we may have to include that in income when it's being removed. So it must be distributed from that IRA. And the calculation is going to be based on the overall value of the assets. So one way to assist is maybe you have a calculator that will calculate that, or if you have a IRA recharacterization or excess removal worksheet, a census offers those. That's a good way to assist in calculating what that net income attributable is. So when we look at that, the net income attributable is based on the overall investments of that. So once we've calculated that NIA, we're going to remove or recharacterize the excess contribution plus the net income attributable. So once that is done, the IRA owner should give you direction of how they're handling this. You would issue a check for the total amount of the excess along with the net income attributable if they're removing the excess. If they are distributing the excess along with the net income attributable, well, the excess portion, there's no tax implication, but the earnings associated that will be subject to income tax, and they may have to claim that as taxable income. And then, clicked a little too fast. Along with that, they could be subject to the additional tax for early distributions if they happen to be under age 59 and a half. So they would remove the excess on or before the tax deadline plus extensions, generally October 15th. We removed the excess contribution from the IRA. We also removed the net income attributable from the IRA. The IRA owner does not claim that contribution as a deductible or non-deductible contribution on their tax return, or for non-deductible contributions, IRS Form 8606, non-deductible IRA contributions. But they are, if they are under age 59 and a half, they do have to pay the 10% early distribution penalty tax. So those are our current rules. Now, one thing that I believe Secure 2.0 has changed is that if they timely remove this, and again, this information is found in your book, but one thing Secure 2.0 did was, I believe that has now removed the early distribution penalty tax if they get that corrected by October 15th. So another change under Secure 2.0, and Congress, by doing that, is just simply indicating to the taxpayer, hey, you made the correction timely, we're not going to assess additional penalty taxes. But the NIA would still have to be included in income. So one thing on page 26 there, if you take a look at that last bullet point, pay the 10% early distribution penalty tax, you can make a little note there that Secure 2.0 has repealed that 10% early distribution penalty tax. Now, that is one thing to keep in mind when we talk about that with that change. So that's going to indicate that they no longer are subject to that early distribution penalty tax. Any questions on removing the excess before the deadline? We'll take a look at the reporting for that here next. Any questions? Okay, now let's take a look at an example. Recall Lisa had that $3,500 excess contribution. We calculated what the NIA is for Lisa to remove that. So $3,500, $3,513.16 is going to be the gross amount of the distribution. Now, the taxable amount will be listed, the NIA only, in 2A. So we're going to mark that NIA only. That's the taxable amount for removing that excess timely for Lisa. So then we're going to look at what distribution code we're going to be using. We're going to either use a code 8 or a code P for removing that excess. And when we take a look at that, if it's due to death, we see we have a code 1 or a code 4 due to death. The beneficiary is correcting it for the taxpayer. Code 1 means an early distribution. That means it's subject to a 10% penalty tax if they're under age 59 and a half. This is going to go away because of the Secure 2.0. If it's from a Roth IRA, we use a code J. So when we're looking at the reporting. So let's take a look at when we use code P. So using code P is if the IRA owner distributes the excess before the deadline in the year after the year the contribution was deposited, but before their tax due date plus extension. So if it's corrected in the calendar year after the contribution was deposited, we don't look at what tax year it was for, we look at what year was it deposited. We'll use a code 8. And then if it's from The Roth IRA, which we saw with Lisa, we use a code J in connection with that. If it's being corrected in the same calendar year that the contribution was deposited, but before the IRA owner's tax return due date, plus extensions, then we use a code 8. So if it was deposited in 2022 and removed in 2022, we're going to use a code 8. If it was deposited in 2022 or in 2021, but removed in 2022, then we use for this 2022 1099-R the code P. So we have to know what year that contribution was made and removed. So code 8 will be used when it's removed in the same year. So even if it's a carryback contribution for the prior year, but it gets corrected in that year, we're going to use a code 8. Any questions on the coding of that? Any questions?
I honestly don't have any questions, Jeff, but this is how I always remember the 8 and the P.
Okay.
Is because one's same year and one's different years. So if you draw a line left to right and cut the 8 in half, so it's top to bottom, they look the same on the top as they do on the bottom. So it went in 22, removed in 22. Whereas if you cut the P in half left to right, it looks different on the top than it does on the bottom. And therefore it went in one year, it came out in a different year. So with this tax statement, it went in 21, removed in 22. That's how I always remember the 8 and the P, is cut them in half left to right. Too much time in hotel rooms, I suppose.
Okay. Very good. That's a little trick for recalling which code should we use. All right. Okay. Now, before the deadline, the other way to do that is through a recharacterization. I've already talked a little bit about this. The recharacterization allows them to remove a current year IRA contribution from one IRA and move it over to the other IRA. In essence, what we're doing is we're treating it as if we made it to the IRA that we're recharacterizing it to. So we made a current year contribution to a traditional IRA. Oh, shoot, I don't get that tax deduction. I should have just put it in the Roth since those contributions aren't deductible. Well, we take that $6,500 contribution, calculate the NIA, and we'll move that over into the Roth. Now it's treated as a $6,500 Roth contribution. Or maybe we made a current year contribution to a Roth IRA. Wow, I got a big raise this year. I'm not eligible to put that Roth contribution in anymore, but I need to keep saving for retirement. Well, we calculate the net income attributable and we move that $6,500 contribution out of the Roth IRA and over to the traditional IRA as a recharacterization. And now we're just simply treating it as a traditional IRA contribution. So recharacterization is just, oops, I put it in the wrong IRA. I should have put it in the other type of IRA, and we simply move it. And it will be a direct movement. So we're treating that as a distribution out of the traditional IRA and a recharacterized contribution into the Roth IRA. So we're going to take a look at the tax reporting that we're going to have to do. Okay, so recharacterizations, when we talk about recharacterizations on page 30 there, when we are doing a recharacterization, we could recharacterize all or just part of it. So it doesn't have to be the full contribution when we're doing the recharacterization. Recall Lisa had that excess of $3,500. That was a true excess because she didn't have eligible compensation for that. So that had to be removed. But let's say she did have eligible compensation, but her modified adjusted gross income fell within the phase out range, and she was only eligible to make the $2,500 or into that. So just the part that was not eligible could be recharacterized to the Roth. Now it's up to the IRA owner to tell your bank how much that is and what they're moving if it's just a partial contribution. The tax year isn't going to change when they do that. So it's still treated as that contribution for that tax year in which they've made that for. So that's not going to be effective. It's a direct movement between the IRAs, so there's no constructive receipt of the assets. We still report the original contribution that was made, so we don't change any of that original tax reporting. That's where then our tax reporting shows it coming out as a distribution out of that IRA that we made the contribution to, and then reported as a recharacterized contribution. So we have to notify the financial organizations if we're moving it from one to another, but oftentimes this is just done within the same bank. So when we're looking at that. So when we do that, again, we if they have multiple contributions, maybe they made contributions monthly and then they're changing that. Well, if there's multiple contributions and we add all of those together consecutively, we only have to do one NIA calculation. But if they choose, they could skip months and that. I say don't let them do that. Just calculate the original one to make the calculations for NIA much easier. And then when they make that recharacterized contribution going into the other IRA, they should make an irrevocable election at the time of deposit. So when they do that, they should be notifying the financial organization that they're doing a recharacterization. So they should notify you of that recharacterization and that they're going to do that. One way to do that is with the recharacterization election form. This is a form that a census has that you can find on page 32. And that captures that the amount. We're asking what tax year that's for. We can calculate the NIA. In fact, the back of the form that a census has. And if you're using Wolters Kluwer's, take a look at theirs. I think they have the NIA worksheet on theirs as well. At least the last one that I looked at had that, and that will tell you how much that is. So that assists in determining how much that is and calculating what that net income attributable is when they do that. So just an ancillary form that could be used to do that. Okay, now let's just take a look at the original contribution. What year was it for? We want to note that as well. And then where are we moving that to? So it's going to be the name of the accepting when it's between two different financial organizations and how to do that. So this is just an ancillary form. Who's the accepting trustee? So if you're recharacterizing it to another bank, we want to get both the original trustee's information and the accepting IRA trustee or custodian's information. Okay, so tax reporting. How do we report those? We're going to look at that and then we'll take a short break here. So when we look at recharacterizations, okay, we will use a code R in box 7 when we're doing that. If it's a prior year recharacterization, if it's a same year recharacterization, we're going to use a code N. So we'll put the amount in box 1 along with the net income attributable. In box 2A, we're going to enter 0 because there's no taxable amount on a recharacterization. The monies are still staying in the IRA. And then box 7 is going to be code R if it was made for, say, 2021 and recharacterized in 2023 or 2022, pardon me. So that's the prior year. And we put the tax code R in there. We're not going to mark the IRA SEP simple box, so we'll have that. If it's done in the same year, we will use a code N. So for recharacterizations of the contribution that was made in 2022 and recharacterized in 2022, we will have the gross amount along with the NIA in box 1, 0 in 2, and then we will have code N. And again, we don't mark that SEP simple box. So that shows the money coming out of the IRA. And then the other side of it, again, we will report the recharacterized contribution along with the NIA coming in box 4. So $3,513 and change coming out and now going in will match that up for the IRS and the IRA owner. So box 4 will have that. Box 5, of course, is our fair market value, the 12/31 year-end balance, and then the type of IRA that's receiving it will be marked in box 7. So that's the tax reporting. Any questions on reporting recharacterizations? Any questions? Okay. Any questions? All right, let's take a 10-minute break. We'll give you a chance to stretch, and then we're going to talk about correcting excesses after the deadline. So I'll put the timer up here, and we will resume at approximately 11:50 or 10:50, pardon me, 10 to 11. Okay, welcome back, everyone. Does anyone have questions on removing excesses before the deadline or recharacterizing a contribution? Any questions on that? How many of you have had to calculate the NIA and recharacterize a contribution for one of your customers? Has anyone had to do a recharacterization? Chat that in if you've had to do a recharacterization. Anyone do a recharacterization? Kathy has. Have you done very many, Kathy? Oh, interesting. Several. You've got a number of people that keep changing their minds then. I like to ask that question because oftentimes these are recharacterization is one of those transactions that some financial institutions don't do very often. Debbie and I occasionally will go out and do compliance assessments of IRA departments for different financial institutions. And one of the things we look at is that tax reporting to make sure that it's being done properly on distributions and contributions for the Form 1099Rs and 5498s. And I always ask for samples of recharacterizations. And oftentimes the financial institution doesn't have any for me to look at, or if they do, there's only been a few that we've been able to review. So that's why I always like to do a little poll. How many of these types of transactions get conducted by different financial institutions? So any questions then on these? I mean, if you do, chat those in. I'm not seeing any right now. Okay, the last part of this section is correcting excess contributions after the deadline. So we want to talk about removing that. So recall our deadline generally is going to be October 15th following the year of the contribution. So they have until their tax deadline, plus extensions if they file for an extension, and they are afforded an automatic 6-month extension to get that corrected by October 15th. So we can correct deemed excesses or true excesses before that deadline. If we do, we have to calculate that net income attributable. After we've hit October 15th, our deadline, then only true excesses are permitted to be corrected. So we can only correct true excesses after the deadline. How do we do that? Well, we can carry it forward. In other words, redesignate that to the next subsequent year. Or we remove only the excess contribution. We don't have to worry about the net income attributable on that. However, because we've hit that deadline, they may be assessed a 6% penalty tax on the excess contribution. So when we look at this, we can remove the excess contribution after the deadline by redesignating that or carrying it forward, or remove just the excess contribution. Any deemed excesses have to remain in the IRA, and we can't do that. So if we take a look at how we can do this through carrying forward, this is the easiest way for your financial institution to handle it. So if you have someone that wants to carry it forward or redesignate it to a future year, your bank, all you have to do is report that original contribution on the Form 5498. It's then up to the IRA owner to carry it forward on their own individual income tax return. So if they're carrying it forward, we're simply leaving it in the IRA, and then they apply it as a credit towards a subsequent year's contribution. So the amount carried forward plus any other contributions cannot exceed 100% of their eligible compensation. Again, 6,500 for 2023 plus catch-ups. The IRA owner may deduct the redesignated amount or claim it as non-deductible on Form 8606 if they're doing that. So that's anything at your bank has to be concerned with. That's all on the shoulders of the IRA owner as a taxpayer. So when they do that, though, however, they are going to be subject to a 6% penalty tax on that excess contribution. And the IRA owner carries it forward on their tax return. So it gets reported on Form 5498 for the year that it's made. That's the only reporting your bank has to do, and then it falls on the shoulders of the taxpayer. So we've got an example of carrying it forward here on page 37. Let's say they made a 2020 contribution of $24,500 into their IRA. So how did that happen? Who knows? Maybe they got a SEP or individual contributions mixed up, or maybe more likely it could have been maybe an invalid rollover or something to that effect, and it becomes a regular contribution for that year. So when we have that, we've got $6,000 they were eligible to contribute. So now they have an excess contribution of $18,500. So they pay the 6% penalty tax on that amount. Well, they carry it forward and treat it as a contribution now for 2021. Well, they can make $6,000 as a regular contribution in 2021. So they have still an excess in 2021 of $12,500. So they pay the 6% penalty tax on that amount, and then they carry it forward into 2022. Well, they still got, they redesignate that as a $6,000 contribution in 2022. They leave it in. So now they've got a $6,500 excess in 2022. They pay the 6% penalty tax on that and carry it forward to 2023. Well, they now have used up that contribution with their $6,500 contribution. So after 2023, there is no longer any penalty tax on that. So all you do is report the regular contribution that was made on the 5498 of 24,500, and then all of the moving forward and paying the 6% penalty tax is up to the IRA owner, the taxpayer. They'll file IRS Form 5329, which is additional taxes on qualified plans, including IRAs and other tax favored accounts. That is the same tax form that we would claim the exception to the early distribution penalty, but we also paid the 6% excess tax on that as well. So carrying it forward, it's up to the taxpayer. You just simply report the original contribution going in. Okay, so after the deadline, we can only remove the excess contribution. We leave the net income attributable, and then it's up to them to pay the 6% penalty tax. So when removing that, they must remove the excess contribution, but not the net income attributable. That stays in the IRA. If the IRA owner contributes more than the annual limit, 6,500 for 2023, plus the catch-up contribution if they're eligible, the distribution is taxed in the year removed. So this results in double taxation. In addition to the 6% penalty tax, the IRA owner must pay a 10% early distribution penalty tax on the excess amount if they are under age 59.5 and do not have an exception. So if the total contributions for the year are less than or equal to the annual limit, then we remove just the excess, leave the net income attributable in the plan, And then they will have to pay the 6% penalty tax. So when we take a look at that, these are additional taxes that the IRA owner has to work out with their own tax advisor when they're looking at that. Okay, now sometimes an excess could occur as a result of an invalid rollover, maybe coming out of a 401k plan or other employer sponsored plan, because the participant relied on incorrect information that was given to them from their plan administrator. The participant can remove that excess contribution without taxes or penalty when that happens. So when this happens, they can still remove the excess without any taxes or penalties when it's removed timely. So for the maximum amount to be increased as an excess contribution due to incorrect information supplied by the plan, they can remove this as an excess contribution as an invalid rollover. So that's an example where they may not be subject to the tax or penalty when they're removing it due to bad plan information. Any questions on removing the excess after the deadline? Okay, let's take a look at how we report those then. Now, after the deadline, we're simply going to remove the excess. We leave the net income attributable in, and we're going to enter the total amount of the distribution in box 1. So the total amount of that excess being removed in box 1. In box 2A, we're going to leave that blank, taxable amount. So we'll leave that blank. And then in 2B, the taxable amount not determined will be checked. So check the taxable amount not determined box. And then for traditional IRAs, it will be based on the age they are. So code 1, if under 59.5, if over 59.5, we'll use code 7 as a normal distribution and then mark the IRA simple box. For Roth IRAs, it's going to be based on their age again. If they're we are going to use code T if we don't know the 5-year period has been met, but they're over 59.5, disabled or deceased. Code Q if they've met the 5-year period and one of those events, or all other distributions, then we use a code J. And of course, we do not mark the IRA simple box when removing those excesses. So after the deadline, we just start coding it with as a distribution out of the type of IRA, traditional based on their age, 1 or 7, Roth using the alpha code, whether it's qualified or non-qualified, and mark that. And then 2A, we of course leave blank because it's an excess after the deadline. Any questions on the tax reporting? Okay. I'm going to turn it over to Debbie, and we're going to start in with RMD's required minimum distributions before lunch.
Thanks, Jeff. So we are going to be moving, as Jeff said, into required minimum distributions. We've had a bit of a change with Secure 2.0, so I'm going to point that out pretty quickly when we start the section. But first, I want to take a look at page 41, and we are going to be able to calculate a required minimum distribution, or RMD. We'll also discuss the RMD rules and explain the RMD reporting requirements as part of this section. So the first thing that I want to point out on page 42 is that this section only applies to traditional IRAs and simple IRAs. Those are the only 2 IRAs that have a required minimum distribution, or RMD. Generally speaking, that then has to be taken by what's called your required beginning date, which is April 1 after the year in which you reach RMD age. Now, what you'll notice in the second paragraph on page 42 is that that age was increased as a result of Secure 1.0, if you will. Back in 2019, when Secure was passed effective 2020, that moved from 70.5 to age 72. And so it does indicate that that applies in 22 and later years. That is in the fourth line of the second paragraph. However, you have some white space at the bottom of page 42. And I'm going to go ahead and bring this back up. This is that article that I referenced this morning. I have it highlighted here that Secure 2.0 delayed that RMD age or changed it from 72 to 73 in 2023. So anybody who turned 72 last year in 2022 would in fact have an RMD in 2022 and still have to take it no later than April 1 of 2023. So they need to take it before their RBD in 2023. Excuse me. No one will start RMDs this year because the age is 73 for the new start effective 2023. So anybody turning 73 this year would have been the same individuals that turned 72 last year that already started their RMDs. Therefore, no new RMD people in 2023. In 2024, any individuals who turned 73 in 2024 will have their first year of their RMD. So the bottom of the screen, and I'm going to go ahead and pop this back up for just a moment. Bottom of the screen talks about the 72nd year if you were born on or after July 1 in 1949. For 73, that is birth years in 1951. So if you were born in 1950, if I did the math right, and I'm going to check it really quick, 1951 plus 73 is 2024. Perfect. So if you were born in 1951, you will be 73 in 2024, and that will be your first year. So again, going back to the article, we are now going to be 73 starting in 2023. Eventually in 2033, would be age 75. So be prepared for another change, but not for 10 years, unless something happens between now and then. I'm not going to promise anything. It will move to 75. Now, individuals who are born in 1950 or earlier are unaffected by this change and still have to take their RMDs due by 2022 in later years. So my dad is 80. He's still on an RMD. If my mom turned 72 last year, she still had a 22 RMD, which was her first year. And she, again, still does have to take that, if she hasn't yet, by her required beginning date, which would be April 1 of 2023. The provision is effective in 2023 and later years for those who reach after, okay? So kind of keep that in mind. Before I go any further, questions on this change to 73, the birth years, no new folks this year, anything along those lines? Feel free to unmute or chat. Okay, I'm not hearing anything and I'm not seeing anything in chat, but if anything comes up, don't hesitate to pull it back and let us know, and we're happy to answer any of those questions as they come up. So there still is an RMD. It's still in effect for traditional and simple IRAs. They still have an RBD, which is April 1 of the year after their first year. Every year thereafter, the deadline is December 31st. So my dad is 80. He does have to take his RMD for 2023 by December 31 of 2023. So that delay to April 1 of the following year is only for our folks who start. They can take their RMD for that current year in the year that they turn 73. or they can take it by April 1 of the year in which they technically turned 74, the year after they turned 73. So that is all still the same. It's just the age start that changed as a result of Secure 2.0. The calculation process hasn't changed. So in order to calculate an individual's RMD, we take their IRA balance at the end of the prior year. So for my dad, for calculating for 2023, we would take his balance at the end of 2022 in his traditional IRA, and we would divide it by a distribution period. The answer to that mathematical question is his required minimum distribution. That is the annual amount that he has to receive for that particular year, in this case, 2023. He can then divide that amount into more frequent payments if he wants. So he could, take that annual amount, divide it by 12 and take monthly payments, divide by 2, divide by 4, keep it annual. As long as he receives that amount to satisfy the RMD for this traditional IRA, that's by his deadline, which for him is 12/31. And most folks outside of the first year folks, and again, we have no first year folks this year, would be December 31st. First year's April 1 of the following year, year after their second year, if you will. Now, the distribution period is what it's called now, but under the proposed RMD regulations, let me get my annotation back up here. Whoops, I did not mean to click that. Here we go. So under the proposed RMD regulations, which we're supposed to follow as final regulations, this will be changed to applicable denominator. So you'll hear myself or Jeff or other individuals that you're working with talking about the distribution period or the divisor or the applicable denominator. Those are all really kind of the same things. The applicable denominator gets you the divisor that you use. Distribution period, again, same term, same meaning, or different terms, same meaning. It is the life expectancy, if you will, for that particular individual based on their age. So if you hear distribution period or applicable denominator, it's going to be the same thing. The balance is generally December 31st of the prior year, but it can be something different. It can be adjusted. So if you are taking a look at on page 43 now, this is based on 2022 calendars. And again, I'm just looking at 2022 to 2023 so that you can see for 2023 how this would be in effect. Since we're kind of in that time frame right now at the beginning of the year where, activity may have happened at the end of 22, not yet coming in 2023. So generally speaking, we would take my dad's December 31 balance at the end of 22 and use it to calculate his 2023 required minimum distribution. But my dad is not a huge fan of having to take his required minimum distribution, even though I've nailed it down multiple times and said, it's the R stands for required, so you kind of don't have a choice. But my dad thinks he's pretty smart. So my dad did a distribution, either a distribution to himself, which he then rolls over within 60 days, or it was a transfer payable to the other financial organization on December 30th of 2022. And he hasn't yet taken his RMD for obviously the next year. 2023 won't start until January. So he takes all of the money out at the end of December, right? And there's no balance in that account as of December 31st because the balance has now been transferred or it's been distributed to him with his intent to roll over within 60 days. Even by my math standards, which theoretically are not great, if you divide anything by 0, you're going to get 0. So my dad thought, hey, if I take all the money out, then my balance is 0 and I won't have an RMD for the following year for 2023. But what the tax rules state is that if you do a transfer in 1 year that comes in the following year, or a distribution in 1 year that you roll over within the 60 days into the next year, whether it goes into a different traditional or the same traditional, you have to take the amount of the rollover or transfer deposit, and my dad has to add it to his balance at the end of the year on the receiving IRA and get an adjusted fair market value. And then his 2023 required minimum distribution will be on the adjusted fair market value. The balance in that account at the end of 23 plus the amount that he rolled over or transferred if it left in the prior year. So for those of you that might use IRA Direct, this is why on your core system, or on the IRA Direct system rather, it will ask date money left and date money entered, because it's looking for those prior year transfers and rollovers where there's multiple years involved. If you are looking at the IRA Direct monthly distribution report and you see two values in fair market value column, that's because one is the actual 12/31 balance and one is the adjusted balance based on that multi-year activity. So, excuse me, ultimately, that's where that one instance is where it would be adjusted. Question came in, does the IRA owner need to notify the receiving bank of the outstanding transfer or rollover? Technically, the RMD is the owner's responsibility to ensure that they receive. However, if they are set up on your core system with your financial that you will automatically distribute their RMD monthly, quarterly, annually, what have you, then what you're going to be looking for is when did the money leave and when did the money come in, only for the folks that are of RMD age. For me, it won't matter. For my dad, if he's doing a transfer in, question you might want to ask is, although it's not technically your responsibility underneath the compliance laws, the owner may see that different since they are signed up for a minimum distribution to be calculated by your organization on your core system. So you might want to then ask my dad, did this money leave the other financial organization in the prior year? Now, if it's a check, you can see the date that it was issued. And so you'll know if it was issued in 22, but it's coming in 23. Then I would recommend that you do add it in to let the owner know, because again, they're probably signed up for scheduled payments through your organization. The compliance rule is the owner is the one who has the responsibility of ensuring that RMD is calculated properly and distributed timely. So that will fall back to them from a compliance perspective, but the owner may see that differently from a legal perspective, and potentially, I don't know if they would, but they could potentially go to court over that because they've signed up for that calculation to be done by you. So the answer to that question is the owner should really give you that information from a compliance perspective, but operationally speaking, it's a good time for you to look for those things and to calculate that depending on how the owner is set up. Excuse me. Now, with the rollover, it does have to come in within 60 days, but remember, there's no time limit on the transfer. Generally speaking, those happen pretty quick after the beginning of the year because they're usually mailed and they usually come in. Now, if the owner's coming in with cash, I would definitely ask the question. It's not likely, it's more likely that they'll have a check, even if it's payable to them, but it is possible. So I would just kind of review it. But again, the compliance laws say one thing versus what your owner may think from a liability standpoint. And again, how your system is set up with that owner to calculate them. So that's one instance. The second instance where you might have a multi-year scenario that adjusts the fair market value is if there's an inherited distribution, surviving spouse rollover or transfer. And this would be an example of, let's say that my dad passed away in 2022. He is 80, he has an RMD. My mom is 79, so she is also of RMD age, and she has chosen to move it into her own account. However, she does not do this until the year after the distribution. So the money was in an inherited IRA at the end of 2022. And now she's moving it over via transfer or rollover into her own account. That money hasn't been accounted for anyone's RMD for 23. Obviously, my dad passed in 22, so there was no RMD for 23 for him. And it wasn't part of my mom's balance at the end of 23, so it didn't get calculated as part of her 23 fair market value or adjusted fair market value. So in this case, excuse me, same answer to that I had for the last one is that I would recommend that you account for that information. When did it leave? Now, in this case, we're talking about both spouses over 73. In this particular case, to have an RMD, the receiving owner has to be 73 or older under current rules. The deceased owner was in the RMD period as well. And we would adjust that fair market value of my mom, in this case, the receiving spouse, who is of RMD age. We would take the amount of the rollover or transfer that she inherited from dad, and we would add it to her fair market value of her traditional IRA at the end of the prior year. Now, again, if this is a new a new traditional IRA, my mom never had one before, then her balance was 0 at the end of 2022. She opened it maybe in 23 to receive the assets. So her balance was 0 plus the amount of the rollover or transfer into her RMD for that year would just be calculated based on the amount of the rollover or the transfer. If it goes into an existing traditional IRA, it would be added to her existing fair market value at the end of 22 and recalculated. But again, same answer. The owner is the one who, from a compliance perspective, shoulders all of the responsibility to have that calculated and ensure that it's distributed. But from an operational standpoint, if they're set up on your core system to have you send out that distribution and calculate that RMD on their behalf, then these are things you're going to want to watch for and adjust for. Likewise, if you're on IRA Direct, this is something that is looked for and questions are asked, so we know when the money left, when the money came in. If there's 2 RMDs for surviving spouse and the deceased owner of age, then that is going to be showing up on your monthly distribution report on IRA Direct with 2 fair market values, one for the straight and one for the adjusted. If you don't use IRA Direct in either scenario, again, I would recommend that you do adjust for them, because most of the time financial organizations have set it up so that they will then send out that information for their client. They'll pay them their RMD, they'll calculate it for them, and you won't be calculating it correctly if we don't have that adjusted amount. If in either of these scenarios, let's say my dad, we'll just go back to the other one, it's a little easier, but my dad already took his RMD for 23 from you in January, and then this transfer or rollover comes in February within the 60 days, or it's a transfer. Even though his RMD based on his original fair market value is straight 1231 balance at the end of 22 was calculated and paid, now he has an adjusted balance and his RMD has increased. So the difference would still need to be distributed by his deadline. Generally, again, we're talking about 1231 for a majority of folks, and that would still have to be distributed. So those are things that I would look for because of how most systems are set up and most individuals are set up on your core system to automatically have that calculated and distributed. So compliance says one thing, operational says another thing. Questions on those two, anything along those lines? Okay. Now, the distribution period or applicable denominator is on page 44. This is the number of years in which that individual is expected to live based on their age. So no one other than the IRS can actually give you a figure on how much longer you've got to go. But these are based on either what's called the uniform lifetime table or potentially the joint life expectancy table if they have an exception to the uniform lifetime table. Most individuals will be using the uniform lifetime table. The tables are gotten from IRS publication 590B. They're in the back of publication 590B. They are in appendix 1, I believe, off the top of my head. I think I have it, appendix B, excuse me, appendix B in 590B. And that's where you're going to find the uniform lifetime table as well as the joint life expectancy tables that we'll be referring to. I will have samples of the table or a portion of the table in your book for you over the next few pages that we'll be looking at on how to read those, and we will use them for some examples that we're going to do at the end of this section as well. So what the uniform lifetime table is, because again, it's used for majority of folks, is a maximum number of years for that individual based on that age. And this is always going to be based on their attained age in that year. So how old will they actually be? Now, my dad, as I've told you, is 80, but his birthday was in September. So he turned 80 in September. His attained age, September of 22. So his attained age for 2023 is actually going to be 81. So that's what he's looking at from his uniform lifetime table, because he'll be using the uniform lifetime table. So it's going to be, excuse me, always attained age to define or determine determine attained age. It would be current year minus birth year. So 2023 minus his birth year of 1942 would make him 81. So when we're using the uniform lifetime table, we would look for a factor for an 81-year-old. Even though he physically is 80 today, we would calculate his distribution period or his applicable divisor based on his attained age of 81. So we always want to make sure that we're using attained age. The uniform lifetime table is based off of the joint life expectancy table factors. And the uniform lifetime table gives you an automatic 10-year age difference between the owner and that theoretical beneficiary, regardless of who or how many or what that beneficiary is. So the 81-year-old is based on 81 and 71. The 75-year-old is based on 75 and 75 and 65 on the table. So it's based on a theoretical beneficiary who is exactly 10 years attained age younger than the owner. Now, in page 44, second paragraph, in November of 2020, the IRS released updated life expectancy tables that began January 1 of 2022. So those are the tables that you're going to find in publication 590B in the back of the table. The other place that you can go for that, I have it hyperlinked. Jeff might know it off the top of his head. It's, if you Google search TD, what did I have it as? I got to look at it again. Sorry, folks. TD 9930, you're going to get the same Federal Register that I have popped up here. And in the Federal Register on page 6, it has the new tables that were released January, or to be used January 1 of 2022 moving forward. Table number 1 to paragraph B talks about the single life expectancy table here. So that's paragraph B. And then C is your uniform lifetime table. So this is going to be table 2 to paragraph C. This is the uniform lifetime table that we'll be looking at, although in a prettier format. And then D is your joint and last survivor table. That is going to start here. And it is much lengthier in view. And you'll notice that also in publication 590B as well. So that's just another place that you can go, is to search TD, which is TD 9930, and that will get you to this Treasury department. That's TD, and then 9930 is the release of this, and that is again the Federal Register starting on page 6. So just to kind of give you an idea. But again, you can also go to publication 590B Appendix B for that information. These new tables haven't, I should say not new tables, but the tables in general have not been updated since 2002. So it had been 20 years since they had been updated and looked at. And certainly people are living longer, and so those life expectancies weren't wholly accurate. So that's why they did this change in effective January 1 of 2022. As part of that release, what they said is that the tables are going to be reviewed every 10 years. So we could see changes every 10 years, or when new mortality studies are published. So it could be more, often than that. But ultimately, it's definitely going to be looked at on a more regular basis than it had been in the past. Excuse me. So on page 45, I have a sample of the uniform lifetime table. And again, this comes right from that Treasury TD 9930 that I showed you, or publication 590B Appendix B. You're going to find the same information back there. This is just laid out in a different visual format for you. But again, it's always based on the owner's attained age. So it's current year 2023 minus their birth year. And in this case, that owner ends up having an attained age of 75. That's how old they're going to be in their birth year, on their birthday this year. Doesn't matter if they're 74 today, they will be 75 in 2023. Therefore, we just move across to the right to find their divisor or their distribution period or their applicable denominator. And for the 75-year-old, we would use the factor of 24.6. Now, my dad is 80 today, but his attained age is 81 for 2023. So he would be using 19.4. My mom is 79 today. Don't ever tell her I told you that. But her attained age is 80. So she would be using 20.2. So because their attained ages are different, they will be using different factors on that uniform lifetime table. Before we take a look at the exception to the uniform lifetime table, any questions on that? Okay, so one thing that I do want to point out on the uniform lifetime table, and I can actually use life experiences on this. I have two great uncles, both on my mom's side, but one on my grandmother's side and one on my grandfather's side, that one is using the uniform lifetime table. It's Uncle Harold. He's widowed. His children are his beneficiaries on his IRA. So he doesn't qualify for the joint life exception that we're going to talk about in just a moment, but he has an attained age this year of 104. So he is going to be using 4.9. So we would take his balance at the end of 2022, adjust it as necessary, and divide by 4.9 for Uncle Harold's 2023 RMD. Again, he's the one that's responsible for ensuring that that's calculated properly and that it's distributed timely as far as the IRS is concerned from a penalty standpoint. Excuse me. But he would be using 4.9. With these new tables, they have stretched out to 120 plus. I believe the old tables used to be 115 plus, but now they go to 120 plus. And if you were only taking your minimum every year, you'll never outlive your RMD or your IRA, excuse me, because you're taking just the minimum. So your balance is always going to be divided by 2.0. Obviously, if you take more than your minimum, which is allowed, you could deplete your IRA before you've passed. But if you are taking just the minimum every year, then you will never outlive your IRA. Now, some folks will qualify for this uniform lifetime table exception, and that takes us to page 46. My Uncle Harold is widowed, and he is using the uniform lifetime table. However, my Uncle Bud is married to Aunt Marion, and she is his sole primary beneficiary. He doesn't have the kids listed as primary beneficiaries. It doesn't matter if they're listed as contingent, but Aunt Marion is the only excuse me, only primary beneficiary on Uncle Bud's IRA. Uncle Bud this year happens to be 105. His attained age will be 105. Aunt Marion is 25 years younger than him and a nurse. Hence, he's 105 and still living at home. That's my theory anyway. He gets to use the uniform lifetime table exception because his spouse, Aunt Marion, is the sole primary beneficiary of his IRA, and Aunt Marion is more than 10 years younger than the owner. She's 25 years younger than him in this case. If their attained ages are exactly 10 years apart, so if I use my parents as an example on this one, if dad was 81 this year, mom was 71 this year, that's exactly 10 years. Then it's the uniform lifetime table. The only time that you can, yes, then you can use you have to use the uniform lifetime table. The only time you get to use the exception and use the joint life expectancy table is if my mom is more than 10 years younger than my dad. So it would have to be 70, she'd have to be 70 attained age, and he would have to be 81 for an attained age in order for my dad to use this joint life expectancy table instead, this exception. Because remember, the uniform lifetime table is exactly a 10-year age difference. So that's kind of what we're looking at. So again, always looking at attained ages. Now, I also want to point out, again, it's more than 10 years younger than the owner. So for Aunt Marion, even though she's on an RMD and Uncle Bud is her sole primary beneficiary, Uncle Bud is not more than 10 years younger than her. So she would have to use the uniform lifetime table. both spouses cannot use the joint life expectancy table the same time. The younger spouse will be using the uniform lifetime table. The older spouse may be using the joint life expectancy table if it's qualified. So the spouse has to be the sole primary beneficiary of the IRA. If Aunt Marion is one of the three beneficiaries, because the kids are also listed as primary beneficiaries. So he has Aunt Marion, Kim, and Sunya listed as primary beneficiary of his IRA. He's using the uniform lifetime table, even though Aunt Marion is more than 10 years younger than him, because she has to be the sole primary beneficiary of the IRA. So in reality, Uncle Bud has Aunt Marion listed as the sole primary beneficiary of his IRA. She is also more than 10 years younger. So he's using this, using the joint life expectancy table. We would need the attained age of both Uncle Bud and Aunt Marion in order to determine the applicable denominator, distribution period, divisor for Uncle Bud's calculation for his required minimum distribution. So the table or portion of that is on page 46 for us. Again, this can be found in that Treasury Department Federal Register release, that TD 9930, if you Google that, or on the IRS's website, if you do a search for 590B, as in boy, it will be in Appendix B in the back. And again, that's where there was the multiple charts. So this is just a portion of the chart. What we need to do to read the chart to get the table, to get the divisor, the denominator, applicable denominator, distribution period for Uncle Bud, is to find the attained ages of both parties. In this case, we're going to say Uncle Bud is 75, and we're going to say that Aunt Marion is 56, because that's what I have up on the screen. Where you find Uncle Bud's attained age on the chart, on the top or on the side, doesn't matter. Aunt Marion could be on the top or on the side, it doesn't matter. It's wherever you find those two ages on the same chart, okay, on the same table page. Where those two then meet is the distribution period for Uncle Bud, the older of the two spouses. So we would take Uncle Bud's balance at the end of 2022, adjust it as necessary, and divide it by 31.5 to get his RMD for the year. Again, he can divide that into more frequent payments if he would like, but that's the minimum that he has to ensure is withdrawn by his deadline. Because in this example, he's 75, his deadline would have to be December 31st of 2023. Now, the following year, Uncle Bud will be 76, Aunt Marion will be 57, assuming that she is still the sole primary beneficiary and alive and kicking, and they're married, we would be using 30.6. You'll notice that this just kind of goes down at an angle based on the age. So 78 down to, what is that, 359, that takes us to 28.7. Looking at the exact 10-year age difference that I mentioned that we use on the uniform lifetime table, and it's taken from the joint life expectancy table. If you look at an 80-year-old, oh, that won't work, 70. Yeah, no, that would work. So 80 and a 70-year-old will get you 20.2 right down here. If we go back to the page 45, you're going to look for an 80-year-old, and you'll notice that that is 20.2. So that comes right from the table. It's an exact 10-year age difference. So again, it has to be more than 10 years younger for that spouse in order to use this joint life expectancy. Questions on reading that table, joint life expectancy, how it's functioning, before I look at the effect of changing beneficiaries and how that can adjust your RMD calculations? Excuse me. Okay, so on page 47, generally speaking, you're going to be consistent with what you're using for your RMD as an owner throughout your lifetime. Most people don't change their beneficiaries all too often, but there are instances where that does happen, and it will potentially change their required minimum distribution, how it's calculated. They're going to be going from joint life expectancy to the uniform lifetime table in some instances, or it could be the reverse, where they started with the uniform lifetime table and now they're using the joint life expectancy. So we're going to look at Uncle Bud and Uncle Harold again. So Uncle Bud is the one who is married to Aunt Marion, and he's using the joint life expectancy. He has only her listed as the sole primary beneficiary. However, he is now changing from a much younger spouse, from Aunt Marion, to any other beneficiary by choice, not due to the death or divorce of him and Aunt Marion, or death of Aunt Marion. So he has voluntarily changed his beneficiary to Aunt Marion and Kim and Sunya. Or he has voluntarily removed Aunt Marion. She's still alive and kicking, they're still married, but he's now named Kim and Sunya as his primary beneficiary. So whether he's removed his much younger spouse or he's added beneficiaries to the much younger spouse, she's no longer the sole primary beneficiary. In that instance, he can no longer use joint life expectancy because she's no longer the sole primary beneficiary of the IRA. So he will go from joint life to the uniform lifetime table, and that will occur in the same year. That will cause his RMD to go up. Uniform lifetime table is always a larger required minimum distribution because the factor is going to be smaller, which gives you a larger RMD. And so his payment will increase, and he will need to have additional assets distributed by the end of his deadline. And again, same answer to the question that we had earlier. He is ultimately responsible from a compliance perspective for ensuring that enough is withdrawn to satisfy his required minimum distribution for that particular year by his deadline. However, this is something that we probably want to watch for because we 99% of the time have that set up that we will be calculating their RMD on their behalf and paying them out accordingly. So if we've already paid him his RMD for the year based on joint life, and now this change happens, that is going to mean increase and in another distribution to satisfy the RMD for that particular year, the difference. Now, in the same category where he's changing from Aunt Marion to any other beneficiary, he is now doing so because Aunt Marion passed away. He's still alive and kicking. She's the one that's passed away, the much younger spouse, believe it or not. Again, he would go from joint life to the uniform lifetime table, but that change would not happen until the following year. So in this case, 2024. His payment will go up, but not until 2024. The reason that it's delayed until the year after is because this is not by choice. Aunt Marion passed, so the IRS is letting him ride with joint life expectancy the rest of this year, but then he will move to the uniform lifetime table next year. If he changes from Aunt Marion to any other designation, again, removing her, adding the kids, probably removing her in this scenario due to divorce, and that beneficiary designation change is made in the same year of the divorce, then he will change the same year. So his increase will happen in the same year from joint life to the uniform lifetime table. However, if it's due to divorce and he does not change until the following year, then the payment won't happen, the change in payment rather won't happen until the following year. In either scenario, his payment's going to go up because he will be going to the uniform lifetime table. However, the timing of when that happens will be based on whether he makes the beneficiary change due to divorce in the same year or in the year after the divorce. Now for Uncle Harold, he started on uniform lifetime table. He's widowed. He has the 3 children listed as his beneficiaries on his IRA. So he's using the uniform lifetime table. However, he now has met Aunt Marion's sister. Uncle Bud and Aunt Marion are not related. And remember, grandfather, grandmother. And so he has now met Aunt Marion's sister, who is now 23 years younger than Uncle Harold. So he has now married his Aunt Marion's sister, and he has now updated his beneficiaries to be only Aunt Marion's sister as his sole primary beneficiary. So he now qualifies for joint life. His wife his spouse is the sole primary beneficiary. However, she has to be more than 10 years younger, which she is. She's 23 years younger than him. And she has to be the sole primary beneficiary for the whole year. Well, they just recently got married, and he named the beneficiary as his new wife, only her, today. So she's not the sole primary beneficiary for all of 2023, Therefore, he will not move to joint life expectancy until next year. He's going to continue out based on uniform lifetime table this year. Next year, he'll move to joint life and his payment will go down. Remember, joint life is always a smaller payment than the uniform lifetime table. Uniform lifetime table is always larger than joint life. It's just the opposite of that. So these are things that we probably do want to watch for, even though the owner has the responsibility of ensuring that it's calculated properly and withdrawing the amount correctly by the deadline, because again of how most of those payments are set up on our core systems and the agreement that we have entered into with that client to calculate and pay the respective RMDs. Questions on that at all? Okay. Some RMD rules to look at on page 48 is that each traditional IRA or simple IRA has its own RMD and should be calculated separately because the beneficiaries may be different on the various accounts. But the RMD amount can be withdrawn from any traditional or simple IRA that the owner owns in their own name. It can't be withdrawn from a Roth. It can't be withdrawn from an employer plan. It can't be withdrawn from inherited beneficiary account assets. It has to be withdrawn from an IRA in their name. So my dad has a traditional at Financial Organization A and a traditional at Financial Organization B. Both of them are $500 for the ease of math. My dad can choose to take $1,000 from either one of them, or he can respectively take $500 from each. Because they're both owned in his name, he can do it either way he wants to. He should inform the financial organization that he is not taking the RMD from, that he wants to be owner responsible, that he's going to take it from somewhere else, because again, you've probably entered into an agreement that says we're going to go ahead and calculate and pay for you your RMD unless we hear otherwise. So he should let you know of his plans to do so. It is taxable in the year that it's distributed. So remember that very first year, they have until April 1 of the following year to take out the required distribution for the prior year. So somebody like my mom who turned 72, let's say, because 72 was the old rule in 2022, she has until April 1 of 2023 to withdraw that amount for 2022. If she didn't take it in 22 and she takes it in 23 by her deadline, it's subject to taxes in 2023. She will then also have her 23 distribution because she's already on RMD. She doesn't get to skip anything. She will also have her 2023 RMD that has to be distributed by the end of this year or 12/31 of 23. So it's taxable in the year of the distribution, even if it was a delayed payment from year one, okay? Year two and forward, it always has a deadline of 12/31 of that year. So it's a little easier to say it's taxable in that year because that's the year you're doing the distribution, but kind of keep that in mind. The IRS also says that the first dollars removed are considered the RMD, whether or not the owner's intent was to do that. So remember, my dad has an RMD of $500 with your financial organization, and he wants to go ahead and roll over $10,000. So he takes a distribution of $10,000. Now he's not taking his RMD technically at this particular juncture. This is the first thing he's done all year. And he takes a distribution of $10,000. The IRS says that $500 of that $10,000 is not eligible for rollover because it's your RMD. And you can only roll over $9,500. That is going to be on the shoulders of the client to make sure that they don't roll over their RMD, because now you've given them $10,000. It's their responsibility. From a customer service perspective, it's something that you could certainly say is that this represents your RMD by the IRS, and you can only roll over then the difference, in this case, $9,500. If you're on the receiving side and you have somebody of RMD age who's doing a rollover, I would recommend, again, verifying with them beforehand, before completing the rollover. Did you receive your RMD from the other financial? Is it included in this amount? Because you can't roll over your RMD. The reason I would advocate asking that up front is because, let's say my dad does the rollover of the full $10,000 into your financial organization. It was coming from somewhere else. Technically now my dad has made a $500 traditional contribution and a $9,500 rollover. My dad does not have any eligible compensation, so he's not eligible for a traditional contribution. So now he has an excess, and we have to go back to what Jeff talked about before this section. So it's a good idea from a customer service perspective, if it's incoming and it's in cash or a check payable to them, so it's a rollover, to verify that that RMD is not included in that amount and that was received and kept, because the IRS doesn't care what the owner's intent is. Even if the owner says, yes, I plan to take that in December from somewhere else, the answer is that's not how this works. The IRS says first dollars removed are always considered your RMD satisfaction first. So be aware of that. Now, the last paragraph and 2 subsequent bullet points on page 48 are tweaked because of Secure 2.0. So you have a bit of white space down below. Historically, the IRS has charged a 50% penalty for failure to remove your RMD. So my dad's RMD is $1,000, $500 technically from each traditional IRA, but however he wants to receive that from one or both. But his RMD is $1,000, and he only received $800 worth of it. Okay, so he's short by 200. The IRS charges a 50% penalty on the shortage, not on the whole, but on the shortage. So he's short by 200. So technically it would be 50% of 200 or $100 penalty. That's our pre-Secure 2.0 rules. Now, if my dad didn't receive any of his $1,000, then it would be short by 1,000, and his penalty at 50% would have been $500. What Secure 2.0 is saying now is that, excuse me, that they're reducing the penalty from 50% to 25%. If the failure is corrected timely, they'll further reduce that down to 10%. That is effective for taxable years beginning after the date of enactment, which was December 29th of 2022. So as we read that, that is a 2023 change. So for 2023, the penalty will be 25% for the failure of the removal of the RMD. And again, it's only on the missed portion. If they miss the whole, then they missed the whole, and it's 25% of that. If they missed part of it, then it's only 25% of the part that they missed. If they fix that timely, if they correct that timely, then it would be further reduced down to 10%. Historically, they've been able to request a waiver of that penalty, which is in the 2 bullet points on page 48. And that would be on IRS form 5329. There isn't anything in the tax laws yet that states that's an option. Jeff, I'm going to ask you to weigh in to see if you read this the same way that I've read this, because we haven't gotten guidance on this part yet. But if they're reducing it, if fixed, down to 10%, that leads me to believe that they're not going to offer the waiver opportunity. But I don't know. Jeff, do you have thoughts on that?
Well, that's the one thing we don't know. Congress is the one reducing it. I think it really comes down to the IRS. How closely do they want to look to enforce this? Just a little history on the 50% waiver or the waiver of the 50% penalty tax. In the past, in order to get the waiver, the taxpayer had to pay the 50% penalty tax, file 5329 with their letter of explanation, requesting the waiver. Well, they changed that probably about 5-6 years ago now, and said, just don't pay the penalty tax, send us the letter with 5329 and request the waiver. And if we don't think you deserve the waiver, we're going to send you a letter saying you owe the 50% penalty tax. So that was a change in their policy. So now that they're reducing it from 50 to 25, and if you timely do it, down to 10, how far does the IRS want to really go to monitor that? I'm not sure what's going to happen there, because the last several years now, from what I've heard from customers, is that individuals have actually been getting the waiver. In order to qualify for the waiver, you have to remedy the situation. In other words, take the missed RMDs, which means they've collected the necessary income tax that
Correct.
was due anyway. So it was just in a later year when distributed. So I'm not sure what's really going to happen from the IRS's standpoint because of this. Another study was that I think it was by the one of the other governmental entities that did audit on the IRS said they're missing a lot of RMDs in collection of the tax just from people not taking RMDs. So we'll have to see how far they go in really enforcing this.
Perfect. Thank you. I appreciate the kick in on that one. But like Jeff said, we don't know with those last two bullet points. Good news is that is all going to be done with their tax advisor and not with the financial organization. So the most that we could say is that it's been reduced to 25%, and if it's corrected timely, they'll reduce that down to 10%. From that point, you would need to talk to a tax advisor to determine how to handle that moving forward, and that's kind of where your role is. So those two bullet points underneath the last paragraph there are really kind of in question. But again, what I can say from Secure 2.0 is that it has been reduced to 25%. If timely corrected, they'll reduce that down to 10%. That's the most from a factual perspective that Jeff and I can give you at this particular point. Any questions on that before we finish up with RMD notice reporting and look at our activity? Okay, so we are required to send out an RMD notice to folks who are turning 73 underneath the new rules in a given year. So we 73 or older in a given year. So we only have our older folks this year because nobody's turning 73 that wouldn't already be on it because they would have been 72 last year. So no new folks this year, but all of our existing folks would get it this year, and then next year new plus existing. We're required to send that out to all of our traditional and simple owners who are of RMD age in that particular year or will be in that particular year to let them know they have an RMD. And this deadline to send it out is the end of this month. So it's January 31st. Now there's two ways that we can do this. It's alternative 1 and alternative 2. Alternative 1 and 2, we both have to, under both alternatives, we have to provide a statement that says an RMD is required for the year and the date that it has to be distributed, which for this year, everybody's going to be deadline 12/31 of 23 because there's no new folks. But in years that there's a new folk, like next year, some deadlines might be April 1 of 25 in that case versus 12/31 of 24. We also have to provide a statement explaining that the IRS is going to be getting information that an RMD is due. We're going to be doing that technically on the 5498 for to the IRS. But we do need to let them know in January, the owners, that that's going to be happening. With alternative 1, we then use the actual amount, and you can use the straight 12/31 balance, no adjustments. You can use the straight uniform lifetime table, regardless of whether or not they qualify for the uniform lifetime, or excuse me, the joint life expectancy table. So you can use those factors. Alternative 2 is that you offer to calculate the amount. So you don't actually give them a figure, but you say, hey, contact us if you would like your RMD amount. Now, if they do contact you, you do have a responsibility to calculate the RMD for them. And again, that can be based on the straight 12/31 balance along with the uniform lifetime table. We don't actually send an RMD notice to the IRS in January, but instead we do in in May, we do send them the 5498 and we check box 11 to indicate that they should have an RMD for the following year. So May of 2023 is when we're going to send out our 2022 5498s, indicating to the IRS that, for example, my dad would have this box marked because he is of age for an RMD in 2023. If you're using the 5498 statement for alternative 1, you can use boxes 12A and 12B. 12A would be the date, the deadline by which they have to receive it, and the RMD amount for 12B, and that would then be for alternative 1. The last thing that we're going to take a look at before lunch is our calculations over on pages 50 and 51. So the tables you can look at in the back of the job aids, or you could go back and look at the tables on pages 45 and 46 of the guidebook. So we have Renee, who was born in 1950, and she has 3 beneficiaries who are listed as primary beneficiaries. Her spouse, also born in 1950. We have 2 beneficiary non-spouses born in 75 and 78. Her balance at the end of December of last year is listed and it's not adjusted for any reason. What would, using chat, what would her attained age be in 2023 for Renee? 2023 minus 1950. Any takers? Okay, perfect. She's going to be 73. Do you need the attained ages of her beneficiaries? What do you guys think? Yes or no? Correct. We did not need them because she doesn't qualify for the exception. So in that case, which table are we going to be using for Renee? The uniform lifetime table or the joint life expectancy table? Thank you. We're going to be using the uniform lifetime table because she has more than one primary beneficiary. You don't even technically have to look at their attained ages. You just know there's multiple primaries and we're automatically using the uniform lifetime table. So take a moment to look at page 45 or the job aids in the back and find the attained age for that of a 73-year-old. And it is, thank you very much. It is 26.5. So we're going to take the math, we're going to take the fair market value, we're going to divide by the applicable distribution period, applicable denominator, divisor to get their Renee's RMD for 2023. And what you're going to get is $2,122.94. So we simply took that balance, divided by the applicable denominator, and we got $2,122.94. For Stephen on page 51, he was born in 44, and Darcy, his wife, is the sole primary beneficiary for the entire year. She was born in 1962. He does have Liam listed as a contingent beneficiary who was born in 1984. Balance is listed. What is Stephen's attained age for 2023? What do you guys think from a chat perspective? And again, that's 23 minus Stephen's birth year, 79. Thank you. Perfect. Do you need the attained age of his beneficiary in order to calculate his RMD? What do you think? We do. So what is the attained age of Darcy? Whoa, one too many clicks there. You don't have to do the math. I did it for you. Darcy is 61. Thank you for popping that in chat though. So current year 2023 minus 1962 gets us the attained age of 61 for Darcy because he does qualify for that uniform lifetime table exception. Therefore, we are going to be using the joint life expectancy table. Whoops, since I just said that, I'll just click it up there. So we're going to be using the joint life expectancy table. Using page 46 or the joint life table in the back of the book in job aids, what is the distribution period or applicable denominator for Stephen? You're going to find where a 79 and a 61-year-old meet. Perfect, thank you. So that's going to be 27.0. And then we're going to take the balance at the end of the prior year, adjust it as necessary. We're going to divide by that 27.0 to get our RMD for the year, which is $3,272.84. Questions on anything that we've looked at this morning? Legal issues, excesses, RMDs. Okay, I'm not hearing anything and I'm not seeing anything. So Jeff, I'm going to let you share the screen, pop up your timer. Because mine again not working. Tried it again today. And we are going to go ahead and take a half an hour for lunch, and when we come back we'll pick up with beneficiary distributions.
Okay, the timer should be going. We'll see you all in a half hour. Welcome back, everyone. Hopefully you had a nice little break. We're able to get some refreshments and maybe a little lunch in there. We've covered an awful lot of information so far today. Debbie covered legal issues. We talked about excess corrections and recharacterizations. And then Debbie started out talking about required minimum distributions. This afternoon, we're going to take a look at beneficiary options and also withholding. But before we get started, does anyone have any questions regarding anything that we've covered so far or anything we haven't covered so far? In other words, the door is wide open for questions. If you do, the best way, of course, is to always unmute your phone or computer and ask that question, or you can simply chat that question in. Okay, well, let's talk about beneficiary options next. In fact, there's a lot of times that Debbie and I are on our IRA lines, IRA consulting lines. And when I'm on there are some days where I would just want to pick up the phone and say, IRA consulting, who died? Because some days, 80 to 90% of our calls are questions on beneficiary options. So we want to make sure that you understand that. We've had some changes to these rules that were passed under the Secure Act. So effective January 1 of 2020 is when those changes went into effect. So we're going to describe the beneficiary options when an IRA owner dies on or after January 1st of 2020, because our new rules have been implemented. We're going to make sure you have a good understanding of those. We'll also recognize the differences for different types of beneficiaries. So what are the options for those beneficiaries based on the type of beneficiary they are? So we're going to cover a lot of these rules. We want to encourage any questions that you may have so you have a good understanding of those. So let's get started. And on page 54 of your handout, first of all, I would recommend that your bank implement certain procedures for implementing distributions to beneficiaries of deceased IRA owners. The reason for that is because each beneficiary may have different options, but it's good to have in place procedures when the IRA owner passes away and then the beneficiaries are requesting distributions. Part of that should be get a copy of the certified death certificate. Why? We want to make sure that the IRA owner is deceased. Don't rely on the obituaries. Make sure you have a certified copy of the death certificate. And then once you have that, then you can go back and look at who is named as a designated beneficiary on the account. So looking at the beneficiary designation will tell you who's entitled to those assets. So we would encourage you to make sure you do that. The most up-to-date current signed beneficiary designation is who is entitled to that. Recall, in order for a beneficiary to receive those assets, they must survive the IRA owner. In other words, the beneficiary has to be living. If they did not name a beneficiary, then you might need to go back to the plan agreement and look and see what the default is. As we discussed yesterday, if no named beneficiaries are listed on the IRA, typically the estate of the decedent would become the beneficiary of that IRA. But check your plan agreement, because some plan agreements may have a different default beneficiary. So let's talk about the new distribution rules and how we process those distributions. So we're discussing deaths on or after January 1 of 2020. That is when the changes under the Secure Act got implemented. Excuse me. Now, the first thing that we need to know is the Secure Act gave us new terms. Okay, a new term is eligible designated beneficiary. In the past, under the regulations, we had designated beneficiary. That is still a term that we do use. Designated beneficiary typically refers to an individual. So for most cases, that individual will be a person. But in some cases, if we had a qualified trust, we were able to look through the trust to the oldest designated beneficiary named of the trust, and the trust would be considered a designated beneficiary. Well, we still use that term designated beneficiary. That's simply meaning, for the most part, a person and what those distribution options are. But we now have a new term, eligible designated beneficiaries. Who is an eligible designated beneficiary? Well, the Secure Act defines an eligible designated beneficiary as the spouse of the decedent, an IRA owner's minor child. So this is important, minor child of the IRA owner. It's just not a minor child. It has to be the IRA owner's minor child. Why do I bring that up? Well, maybe grandpa and grandma had an IRA and they named their grandchildren as beneficiaries of their IRAs, and those grandchildren are minors under the law. In other words, they have not reached the age of majority. Well, in that case, they are not considered an eligible designated beneficiary. They would just simply be a designated beneficiary. So the IRA owner's minor child is considered an eligible designated beneficiary. Now, also someone that's disabled, a disabled individual, and the definition basically is saying they must be totally and permanently disabled. Also, someone chronically ill, a chronically ill individual also would be considered an eligible designated beneficiary. And then someone not more than 10 years younger. Okay, Kathy has a question. Is an adopted child considered an IRA owner's minor child? Very good question, Kathy. I would say if they have been adopted by the parents and they have not reached the age of majority, they would be considered the minor child of the IRA owner, or a stepchild. Again, they don't clarify that. They just say the minor child of the IRA owner. So I think a stepchild also, if they had not reached the age of majority, would also be able to be considered a minor child. So good, very good question. As long as it's the minor child of the IRA owner. And I'm guessing for most purposes, since we're talking about federal law and tax deferred savings vehicle, I think these minor children, if they're claimed as dependents by the taxpayer, they would probably qualify under the law. So good question. Any other questions? Okay, so the spouse, the IRA owner's minor child, someone disabled, chronically ill, or our last one, not more than 10 years younger than the IRA owner. So chat in an example. Who would someone not more than 10 years younger than the IRA owner who would that be? Who might be a good example? Someone not more than 10 years younger. I see an answer coming in. Yeah, siblings. Yeah, brothers, sisters, siblings would be oftentimes not more than 10 years younger. They are considered eligible designated beneficiaries. Now, why do we have this term? Well, under Secure Act, what Congress did when they passed that was really accelerated the payments that designated beneficiaries have to take under the law. In other words, the IRS is collecting the taxation from beneficiaries much more rapidly because they're now required basically to distribute it within 10 years. The exception to the 10-year rule, which we're going to define and look at here, is if they are considered an eligible designated beneficiary, they still have the option to take distributions based on life expectancy, typically the beneficiary's life expectancy. Why is that important? Well, their life expectancy potentially could stretch out the taxation longer than the 10-year period under this. So when we look at who are eligible designated beneficiaries, they have the option of choosing life expectancy and taking minimum distributions out of their inherited IRAs that we set up on their behalf. So a spouse always has had that option. The minor child has a special rule where they can begin life expectancy, but then once they reach the age of majority, and under the proposed regulations, that is age 21, then they're going to switch to that 10-year rule. So they can start it, but then they do eventually switch over to the 10-year rule where they have to deplete the inherited IRA assets. Someone disabled or chronically ill, the intent of the law allowing them to take life expectancy payments is to be able to give them a stream of income similar to the deceased IRA owner over their life expectancy to be able to live off of, because oftentimes the disabled or chronically ill are unable to continue working. So that only simply makes sense. Now, the beneficiary not more than 10 years younger. Well, under our RMD regulations, and we'll talk a little bit more about this, is one of the concepts is once required minimum distributions begin, they have to be taken annually, normally by the IRA owner. And Debbie just went over all those required minimum distribution or RMD rules for the IRA owner. Well, if the beneficiary is inheriting these assets, the tax code says distributions that have started under the RMD rules have to continue annually by the beneficiary. So if you think about and those distributions have to continue at least as rapidly as what the deceased IRA owner has done. Well, someone not more than 10 years younger will still continue to deplete the IRA at least as rapidly as the deceased IRA owner. If you think about that table, the uniform lifetime table that Debbie had you look at for calculating the required minimum distribution, that is actually a joint life factor that is based on the age of the IRA owner and a hypothetical beneficiary exactly 10 years younger than the IRA owner. So when we look at this at least as rapidly rule, a beneficiary not more than 10 years younger will still continue taking distributions at least as rapidly as the decedent would have been had they remained alive. So that's why we have someone not more than 10 years younger. So these are who are eligible designated beneficiaries under the new RMD proposed regulations right now. Hopefully will be finalized sometime soon. So we're going to look at these options. Also, the proposed regulations, you'll see a note there at the bottom, expand the definition of not only the 5 that we show here, but it says also beneficiaries of the IRA owner who died before January 1 of 2020, because all of those beneficiaries did have the option of life expectancy distributions, and they are able to continue on those life expectancy distributions when the IRA owner had died before 1/1 of 2020. So these are who the eligible designated beneficiaries are. So let's take a look at on page 55. We've got an overview of the beneficiary options for deaths on or after January 1 of 2020. So when we take a look at that, we've got first on top our eligible designated beneficiaries. These are the ones, as you note, could take life expectancy payments and stretch out the taxation over their lifetime. We also have them separated by the spouse beneficiary, who's an eligible designated beneficiary, and non-spouse beneficiary, who also could be a designated beneficiary. We've broken these out because the spouse always has the most options. Then we have simply the term designated beneficiary. These are all the beneficiaries that don't meet those definitions of eligible designated beneficiaries: the spouse, minor child of the IRA owner, someone disabled, chronically ill, or not more than 10 years younger. If you take a look at that, life expectancy is not an option. So their only option now is going to be to take it under the 10-year rule. We're going to talk more about that. If they're not an individual, they're a non-person, such as the estate, certain trusts, such as non-qualified trusts, or maybe a charity or other entity, they are considered non-persons, and their rules are really the same as prior to the changes under the Secure Act. So nothing really changed for them. So for non-persons, we need to know, did the IRA owner die before the required beginning date, or is it a Roth IRA? If so, then they have the option of the 5-year rule. If it's a traditional IRA owner who started RMDs already and they died on or after the required beginning date, then they continue life expectancy payments based on the decedent's single life expectancy, which we would determine in the year of death. And then we'll look at how we redetermine that using non-recalculation, which is the subtract 1 method. So this is an overview of all of the options. So if we take a look at it, all beneficiaries have the option of a lump sum. We're going to talk about that in a moment, but that's available to all beneficiaries. Basically, they're just simply taking a total distribution of their share of the inherited IRA assets. Now, the designated beneficiaries and eligible designated beneficiaries, they have an option called the 10-year rule. The 10-year rule basically states they have to deplete the assets within 10 years of the date or of the year of death of the IRA owner. So instead of being able to stretch it out, they have to distribute it within 10 years. So we'll talk about those rules as well. So they have to basically deplete all the assets within 10 calendar years. Then for a eligible designated beneficiary, they have one more option, including the spouse: life expectancy payments. Those are simply RMDs, or required minimum distributions, paid out to the beneficiary. So we'll talk about those rules. In other words, they get to stretch out the taxation over their life expectancy. So we'll look at that. And then the spouse has the other options, which they can treat as their own by transferring to their own IRA, or taking a distribution and rolling over to their own IRA, or maybe an eligible retirement plan that they're participating in. So when we take a look at these options, we have a lot of different options that they have. So when we look at that, we're going to talk about these options. Now, take a look at the bottom of that page. In fact, let me pop that up here, page 51, so you know where we're looking at. Oh, page 55, pardon me, page 55. Now, here, blow that up a little bit here, we've got some notes. So under the proposed regulations, and this is pertaining to the spouse, under the proposed regulations that were issued, it states that the spouse beneficiary has until the later of the year following the year of the IRA owner's death, in which the spouse beneficiary reaches 72, to transfer to their own IRA. After that date, the spouse cannot treat the IRA as their own. They must take a distribution and roll that over. So when we take a look at that, oh, let me pop that back up here so you can see that. Take a note of that, once life expectancy payments begin, they have to, if they haven't treated as their own, they would have to take a distribution and roll that over. So something that we came up under the new proposed regulations, that's a little different. Our second bullet is that under the proposed regulations, if the spouse beneficiary of the IRA owner who died before the required beginning date initially elects the 5-year rule or 10-year rule, and then rolls over the assets in the year that she would is age 72 or older, there's a hypothetical required minimum distribution that must be calculated and then distributed to that spouse beneficiary prior to being able to roll that over. So in that case, we have to calculate that hypothetical RMD and distribute that off to the spouse because that's not eligible to be rolled over. So something to keep in mind. And then for designated beneficiaries, we also note that if it's a traditional IRA owner who died on or after the required beginning date, you might want to highlight this, okay? If it's a beneficiary that's at least started RMDs, then basically under what's called the at least as rapidly rule, those designated beneficiaries have to continue taking those distributions out based on their single life expectancy in the first 9 years, and then anything remaining in the 10th year would then have to be distributed under the rules. So when we take a look at that, I just wanted to point out some of those notes. Okay, the 10-year rule is the first year, the year of death, or the following year. Okay, we're going to look at that in just a moment, Kathy. So we will get that answered. So that's a very good question. So let's talk about all of these different options here that we have and break those down. So keep this in mind, page 55, we also have that back in the job aid section where you can look that up. Okay, let's start with lump sum. This is available to all beneficiaries. Any beneficiary can withdraw the entire amount of that IRA in a single distribution. Once they've done that, it's taxable distribution and they're done. So they can do that at any time. They can take that lump sum distribution at any time. There's no options to consider after they've done that. So the lump sum distribution option is available to all beneficiaries. Okay, now the 5-year rule, this pertains to non-person beneficiaries when they die before the required beginning date and have a traditional IRA or simple IRA, or because there's no required beginning date for Roth IRAs if they've named a non-person, or maybe it's the estate of the decedent, then they must distribute under the 5-year rule. What does that mean? Is that if the IRA owner died this year in 2023, they have 5 calendar years to disperse the assets. It doesn't matter how they do it. They can take some each year. They could take some every other year, or they could wait until the 5th year, 2028, and distribute it by 12/31 of the 5th anniversary of the IRA owner's death. So the 5-year rule is for non-persons, and they have to distribute it within 5 calendar years. If it's a traditional IRA owner and we have a non-person, RMDs have started, that means the entity or the estate would have to continue over the decedent's single life expectancy. So for non-persons, those rules have not changed. Now, what's changed under the Secure Act, which is available to any designated beneficiary, including eligible designated beneficiaries, is that they can choose the 10-year rule. So eligible designated beneficiaries of traditional IRA owners who died before their required beginning date and Roth IRA owners also could choose the 10-year rule. Under the 10-year rule for traditional IRA owners that died on or after the required beginning date, in other words, they've already started taking required minimum distributions, the 10-year rule has attached to it what we call the at least as rapidly rule. What do we mean by that? Well, under the at least as rapidly rule, if RMDs have already been started by the IRA owner, once they pass away, they have to continue taking distributions at least as rapidly as the deceased IRA owner. In other words, they have to take life expectancy distributions. This is something that caused some confusion when Secure Act first came out. Everyone saw that the 10-year rule for designated beneficiaries replaced the 5-year rule, including for deaths on or after the required beginning date. What was kind of missed by the industry was the at least as rapidly rule, which has always been in the tax code. And basically that section of the code under 401A9 states that if RMDs were started by the IRA owner, once they pass away, the beneficiaries have to continue taking distributions at least as rapidly as the IRA owner. So with the 10-year rule, if the IRA owner died on or after the required beginning date, they need to continue taking those, and then anything remaining in the 10th year would have to be totally distributed. So let's take a look at that 10-year rule, and Kathy, hopefully this answers your question. Basically, it's 10 calendar years from when the IRA owner dies, okay? So if the IRA owner died this year in 2023, 10 years from now, 2033, everything would have to be distributed by 12/31 of 2023. So under the 10-year rule, we have 10 calendar years to take those distributions. Now, if the IRA owner died before the required beginning date, or it's a Roth IRA because there is no required beginning date, under the 10-year rule, they can take distributions of any amount at any time as long as it's totally distributed by 12/31 of the year containing the 10th anniversary of the account owner's death. So what do I mean by that? Well, they can take some in 2026, 2029, and the rest in 2023 or 2033. Or they could take and wait until 2033 and distribute it all. So it doesn't matter how they do it. They can take some each year. They could do it evenly each year from the total account if they chose, They can wait until the 10th year and take it all. So when we look at the 10-year rule for Roth IRAs, or if the IRA owner died before the required beginning date, then it doesn't matter how it's distributed. So if I were the beneficiary of a Roth IRA, under the 10-year rule being my option, I'd wait 10 years, let it grow tax-free in that inherited Roth IRA, and then take my qualified distribution all tax-free. Where if I took it right away as a lump sum, even though it might be tax-free, if I reinvested it, then we would have to pay taxes on the growth of those investments in those years. So just some planning for that. Now, what it also does is under the 10-year rule for traditional IRAs, since those are includable in income, subject to tax generally for the beneficiary, well, they've got some tax planning for the next 10 years that they might want to consider and discuss with their accountant or tax advisor. What's the best way to handle that? So with traditional IRAs, they've got 10 years in which it has to be depleted. Now, the 10-year rule, if it's a traditional IRA and the IRA owner died on or after the required beginning date, those beneficiaries are required to take life expectancy distributions each year. So beginning in 2024, 2025, 2026, and continuing on, they would have to take life expectancy distributions each year. And it's based on generally their age, and then anything remaining in the 10th year, in our example here, 2033, then would have to be distributed by the end of the year. So the at least as rapidly rule will apply where they still have to take life expectancy distributions. Any questions on the 10-year rule and how that applies? If RMDs haven't started or Roth IRAs, it doesn't matter how they do it. If it's a traditional IRA, RMDs had been started, the beneficiary has to continue those, and then anything remaining in the 10th year would then be distributed to deplete the assets. Everyone good with those concepts? Okay. Now, because of Secure changing to the 10-year rule, there was some confusion on this at least as rapidly rule. And I want to point out here what we have regarding that 10-year rule. We've got some guidance here under notice 2022-53. The IRS issued this last October, basically because a lot of in the industry were just assuming even if RMDs have started, they only had 10 years and could wait till the 10th year to take it all. Well, the proposed regulations clarified that at least as rapidly rule. And basically, we have a number of beneficiaries subject to that 10-year rule that may have been subject to annual distributions and did not take that. Well, as we know, the tax imposed is a 50% tax on the excess accumulation on the amount of the RMD not distributed by the beneficiary. So the IRS has indicated that those that did not take their distributions in 2021 or 2022 would be granted relief of the 50% penalty tax. So the IRS said they're not going to assess the 50% excess accumulation penalty tax for these designated beneficiaries that did not take this. So generally, to get relief for the waiver, as we talked about a little earlier, you had to file 5329 with a letter of explanation of why you didn't take that, and then the IRS could waive that. Well, this notice 2022-53 gives us the relief from that penalty tax. What it did not tell us is whether or not they have to make up the distribution. So going forward, the beneficiaries will be required to take those distributions regarding that. I suspect they don't have to go back and make up the missed life expectancy distributions. If you think about it, the IRS is still collecting their income tax within the 10 years for those deaths that occurred on or after January 1 of 2020. So the beneficiaries are still subject to the same 10-year rule. They're just not going to collect the 50% excess accumulation tax. So we got some relief for those beneficiaries that missed that. Any questions on this notice? Any questions on the notice? Okay. Now, the spouse beneficiary, they can always treat the distribution as their own. How do they do that? Well, they can do that through a transfer. And when we're looking at the transfer, it's going to be from a traditional IRA and the spouse's own traditional IRA. So we're going between like IRAs, so IRAs of the same type. In order to use the transfer, they have to be considered a sole designated beneficiary of that IRA. How are they considered a sole designated beneficiary? Well, if we have other beneficiaries named, maybe it's the spouse and 2 children that are primary beneficiaries, as long as we get separate accounting timely established, which is by 12/31 of the year following death. We'll talk a little bit more about the separate accounting in just a little bit. As long as we have separate accounting established, if we have multiple beneficiaries, then they can simply transfer to their own IRA. And again, it's the IRA of the same type. So if they inherit a Roth IRA, it would be transferred to the spouse's own Roth IRA. If it's a traditional IRA, it may be transferred to the spouse's own traditional IRA. So when we look at it, at these rules, they can simply treat it as their own through a transfer. Now recall, transfers are non-reportable. So we're simply moving it directly into the spouse's own IRA when we do that. So the spouse is able to have those moved over through a transfer. The other option is the spouse could take a distribution of the assets, have it paid to the spouse, and then within 60 days, they could roll that over into an IRA of the same type. So they're able to take a distribution and roll that over into their own IRA. So spouses have these options. So they can do a transfer or a rollover. So even if separate accounting is not timely established, that spouse beneficiary still has the option to do this. This is a reportable transaction. So a distribution will be reported on IRS Form 1099-R, indicating that it's a death distribution being paid to that spouse beneficiary. They then have 60 days to complete the rollover into the other IRA. So we would report the rollover in on IRS Form 5498. Rollover contributions get reported in box 2 of IRA Form 5498, the IRA contribution information form. And then the spouse would have to report that as a rollover on their own individual income tax return. So the rollover would get reported also on their taxes. So the spouse could do it as a rollover as well. Now, under the proposed RMD regulations, if that spouse beneficiary is a beneficiary of an IRA owner who died before their required beginning date, And if they initially elected either the 5-year rule, if death was before 1/1 of 2020, or now the 10-year rule, then rollovers of assets in a year that she attains age 72 or older, a hypothetical RMD must be calculated and would not be eligible to be rolled over. I noted that earlier on page 55 there in those footnotes where we have that special rule that they have to do that. Also, the deadline for a spouse to make election to treat as their own, if they're treating an inherited IRA as their own by making that election, for instance, by transferring to their own IRA or making a deemed election. What's a deemed election? Well, that's where they fail to take an RMD from the account. The proposed regulations state that the deadline for that election is the later of the year following the IRA owner's death, or the year in which the spouse beneficiary reaches 72. After those dates, then they cannot treat it as their own through a transfer, but could take a distribution and roll that over. So these are the options for only spouse eligible designated beneficiaries: the transfer or the distribution and rollover. And I would suspect most of these spouses will simply transfer it into their own IRA. Typically, that's what we see them doing. Any questions on those options for a spouse as an eligible designated beneficiary? Any questions? Okay, now eligible designated beneficiaries have the option of taking annual minimum distributions, RMDs, paid to them. We call those life expectancy payments. Those minimum distributions will be based on the single life expectancy of either the beneficiary, or if that beneficiary happens to be older, the deceased IRA owner, depending on when the IRA owner died. So beneficiaries can take life expectancy payments if they are considered an eligible designated beneficiary. Recall that's going to be the spouse, of course, the minor child of the IRA owner. They can take life expectancy payments, but again, once they reach age 21, they switch to the 10-year rule for that minor beneficiary, and then they would have to deplete it by the time they turn age 31 under the 10-year rule. So the minor child. Eligible designated beneficiaries that are disabled or chronically ill or not more than 10 years younger can choose life expectancy distributions. And to calculate those, we use this formula. We take the account balance and divide it by the distribution period. The distribution period now is based on the single life table. So this is the same formula that Debbie went through for calculating required minimum distributions. The only difference now is, instead of using the uniform lifetime table for calculating RMDs, or the exception to that if the spouse is the sole designated beneficiary of the IRA owner's account and they're eligible to use the joint life factors, then once the IRA owner dies, we switch tables and use the single life table. So the beneficiary must use the single life table when calculating these life expectancy payments when determining that. So when we look at that, we have our account balance. That's going to be the 12/31 prior year-end balance. In other words, the fair market value of the account. And we divide that by a distribution period. Now, Debbie had mentioned this earlier. The proposed regulations have given us a new term and they call the distribution period now the applicable denominator. I would kind of bounce back and forth. I kind of like to use that term distribution period because really what that's telling us is the number of years left to distribute it. But I suppose one of the people in Treasury liked fractions, so they wanted to call it the denominator. So we'll be using that term, I suppose, here in the near future when the final regulations come out and call that the applicable denominator. So to calculate RMDs, we just take the prior year-end balance and then determine what that applicable denominator would be or distribution period, and that tells us how much that life expectancy payment is. Now, how do we determine what that is? Well, we're going to use the single life table. If it's the spouse beneficiary, the spouse beneficiary gets to go back to the table each year and look up what their single life factor is. So the first year we'll look up what their factor is on the table, and then the next year they get to recalculate it and go back to the table, look at what their age is, and continue that up each year by going back to the table. So only a spouse beneficiary has this option. All other eligible designated beneficiaries that were calculating life expectancy factors use what is referred to as non-recalculation. Non-recalculation means that the distribution period in the first distribution year is used, and then each subsequent year we subtract one from that distribution period that we used in the prior year. I like to call this the subtract one method. It describes it a little better, but we still use the term non-recalculation. So that's going to be for non-spouse eligible designated beneficiaries, and then certain non-person beneficiaries when we're using the decedent's life expectancy. So let's take a look at these life expectancy payments and the single life table on page 60. So if we're using recalculation for the spouse begins life expectancy payments at age 68. We take the prior year-end balance, look up their age 68. The applicable denominator or distribution period is 20.4, and that tells us the number of years that that beneficiary has to deplete the asset. So really what that factor tells us is that a 68-year-old should live for 20.4 more years to the age of 88.4 and then die. That's all that factor is telling us. So using recalculation, the following year, the spouse will then be age 69. So our applicable denominator or distribution period using recalculation allows us to go back to the table, look up what their age is in the next year, age 69, and we'll now divide by 29.6 or 19.6, pardon me. The following year, when they're age 70, they would then divide by 18.8. Now, this probably isn't used very often for a spouse beneficiary because more than likely they have treated it as their own and they don't have to begin RMDs until now under the Secure 2.0 when they reach age 73. And as we know, when you looked at the uniform lifetime table, that's a much longer distribution period resulting in smaller RMDs. So a very rare case where a spouse would choose single life expectancy, but the regulations permit it, so that's why we cover it. Now, for eligible designated beneficiaries that are non-spouse beneficiaries, Well, they use non-recalculation. So when we look at non-recalculation, a 68-year-old non-spouse beneficiary has a distribution period of 20.4. So that's our starting point. The next year, though, using non-recalculation, we just simply subtract 1. So our applicable denominator that we divide by, we would then divide by 19.4. In year 3, we would then divide by 18.4. So all those eligible designated beneficiaries, where we look up their life expectancy factor, we only look up that in the year following death and determine what that is. And then each subsequent year, when redetermining the amount, we simply subtract 1 from the prior year's factor to get to our distribution period or applicable denominator. Any questions? Any questions on how we calculate the RMDs for beneficiaries, sometimes called life expectancy distributions? Any questions? Okay. Now, separate accounting, I mentioned this just a little bit, but if we have multiple beneficiaries named and are entitled to that, then separate accounting principles still apply. And basically what we're going to do is set up separate inherited IRAs once we have proof of death. You've received a certified copy of the death certificate. So on your core system, you're going to want to set up an inherited IRA for each beneficiary that's named, that's entitled to those assets. So it's simply transferring to an inherited IRA on your system. You don't need any options or anything from the beneficiary to get these set up on your system. You can simply get it set up. It's a transfer on your system. And when we look at that, we can set that up, and then each beneficiary, if they're an eligible designated beneficiary, has their own distribution options that we looked at on the overview of on page 55. So it's just setting that up. All you need is proof of death, and go ahead and set those up on your system to get the separate accounting set up. Now, if we don't get that set up, then we have to look at who is the oldest designated beneficiary as of what's referred to as the determination date. So that still applies. If the IRA owner died last year in 2022, our deadline to set up the separate accounts is 12/31 of this year. If we are not notified or we don't get those set up by 12/31 of 2023, in other words, you find out maybe in 2024 or later of the death of the IRA owner, then we have to look at who's the oldest designated beneficiary for distribution options. Well, that's not as big as a deal as it used to be. With the new beneficiary options, really only eligible designated beneficiaries will tie into this after January 1 of 2020. But it's still important if separate accounting is not set up, where they may have to go back and look at that. So separate accounting, all we do is set that up. And of course, we want to do that as soon as possible. Any questions on that? Okay. Let's take a look now at our life expectancy options where the IRA owner died before the required beginning date. So on page 62, we've got a breakdown of all of this. So if the death occurred on or after January 1 of 2020, and they died before the required beginning date because it's a traditional IRA, or it's a Roth IRA because Roth IRAs do not have required beginning dates. and we'll assume that separate accounting applies. We've got a breakdown here of all the options, okay? So everyone gets the option of a lump sum if they choose the 10-year rule, and we're looking at the spouse beneficiary first as an eligible designated beneficiary. They could choose the 10-year rule. Under the 10-year rule, there are no annual payments. They can take distributions of any amount at any time, but they totally have to distribute it within 10 calendar years. They could choose life expectancy payments. If they do that, well, life expectancy payments have to begin by the later of 12/31 of the year following death, or the year the IRA owner, the decedent, would have reached age 72. So spouses choosing life expectancy payments have this special rule. So you might just want to note that payments begin the later of 12/31 of the year following death, or 12/31 of the year that the decedent would have reached age 72. In other words, the year RMDs would have normally begun. So when we look at that, we look up what is their life expectancy, and using recalculation, we can go back and use that. So they have the option of that. Now, what are most spouse beneficiaries going to do? Well, they're probably going to choose either this third or possibly the fourth bullet and transfer to their own IRA. In other words, treat it as their own, or take a distribution and roll over the decedent's IRA to their own IRA, or maybe eligible plan. Maybe they're in a 401k plan. The spouse could always roll those assets into their retirement plan. So when we take a look at this, these are typically the options. So the spouse beneficiary has the most options. Any questions on that? Okay. So keep in mind, this is a special rule for spouse beneficiaries only. If they choose life expectancy, they begin the later of 12/31 of the year following death, or when the IRA owner would have reached age 72. Okay, now if it's an eligible designated beneficiary, that's a non-spouse. A beneficiary not more than 10 years younger, someone disabled, chronically ill, or maybe minor child, but again, they can begin life expectancy distributions. So we have life expectancy as an option. They both could choose a lump sum, or they could choose the 10-year rule, but under the 10-year rule, again, no annual payments are required. If they choose to stretch out the taxation, which might be beneficial for them, then payments must begin in the year following the IRA owner's death. In other words, they have to make the election that they want the choose life expectancy and begin those right away. We'll look up what is their life expectancy factor. In other words, the applicable denominator in the year following death. When redetermining that, each subsequent year, we use non-recalculation, so we subtract 1. So when we take a look at that, we're taking a look at using non-recalculation to redetermine that each year. So eligible designated beneficiaries can choose life expectancy and stretch out the taxation on those. Or if it's a Roth IRA, stretch out how long they can continue to have that inherited Roth IRA and potentially take tax-free distributions from the Roth IRA. Questions on distributions to the eligible designated beneficiaries that are non-spouses? Okay, let's then take a look at our designated beneficiaries that are not eligible designated beneficiaries. Okay, well, their option is a lump sum or the 10-year rule. Under the 10-year rule, because it's they died before the required beginning date, RMDs have not started, or if it's a Roth IRA, the 10-year rule just gives them the ability to take it anytime during that 10-year period. So the 10-year rule is going to apply to these non-spouse beneficiaries. So if we have the son and daughter named as the beneficiary, the IRA owner dies this year in 2023, under the 10-year rule, it has to be depleted by 2033. So fairly straightforward under the 10-year rule. If it's a non-person, for instance, they didn't name a beneficiary, so it defaults to the estate. Well, they either have to take a lump sum and have it totally distributed, or they're subject to the 5-year rule. And under the 5-year rule, again, there are no annual payments required. They just have 5 years to distribute all the assets to the non-person beneficiary. So those are the options if they die before the required beginning date. Any questions? Page 62 there is a good little cheat sheet to keep in mind and for a reference in looking at what those options are. Okay. Page 63, we've got an example here. Let's take a look at this example and see if you understand some of the concepts we've just discussed. We've got Eugene. Eugene was born on August 12th, 1956, and died before his required beginning date. He died on July 16th of 2023. Eugene's named Patricia, his wife, as a beneficiary, and his 43-year-old daughter, Maggie, as his beneficiary, and they're both primary beneficiaries. So let's look at when do distributions have to begin for these payments for, first of all, Patricia, his wife. So by what date must Patricia begin her beneficiary payments and why? So when would Patricia have to begin those? Remember, the spouse has that special rule. Take a look at that. When would Patricia have to begin her payments? Well, if she elected it, go ahead and type your answer in if you happen to know when Patricia would begin her payments. And then we'll discuss that. 12/30 died in 2023. Amy Mary say 12/31/24. Recall that special rule. Any other answers coming in? Okay. Well, 12/31/2024 is the year following death, but how old, when was he born? He was born in 1956. So the later of 12/31 of the year following death, which would be 2024. Our answer says 12/28, but it's actually now with the Secure 2.0, so this didn't get updated. If you want to write that down, 12/31/2029, because we've actually changed our age to now age 73. So keep that in mind, that now it's going to be age when Eugene would have reached age 73, when Patricia would have to start that. So make a note of that. Again, these were prepared before. So how about his daughter, Maggie? When would she have to do it? She's considered a non-spouse beneficiary. When does she have to have the assets distributed? He died before the required beginning date. How about Maggie? She's a non-spouse designated beneficiary, but I don't think she meets the eligible designated beneficiary. So when would Maggie have to distribute hers? When would she have to distribute hers? Take a look at page 62 for Maggie. she is subject to either a lump sum or the 10-year rule. So under the 10-year rule, she has 10 years from the year he died. In other words, 12/31/2033 is when Maggie would have to have those assets distributed. Everyone good with those concepts? Okay, so when we take a look at that, the spouse has the special rule. Now, what's Patricia probably going to do? Patricia's probably going to treat it as her own. All right. Now, what happens if we have a traditional IRA owner that dies before satisfying their required minimum distribution in the year that they died? Well, if the RMD was not distributed in the year of death, then the IRA beneficiaries named on the account must distribute the remaining RMD by 12/31 in the year of death. If we have more than one beneficiary named, in other words, multiple beneficiaries, then each beneficiary should remove their own portion of the RMD. So if the son or daughter are named as primary beneficiaries, sharing equally, in other words, 50%, and the RMD was $1,000 that did not get distributed, then they each should take a death distribution of $500, satisfying the amount that the decedent should have distributed by the end of the year. For those RMDs in the year of death, we don't calculate anything any differently. It's simply the RMD amount generally calculated using the uniform lifetime table and then distributed out to the beneficiary in the beneficiary's name and social security number. So that's how we're going to do it in the year of death. Okay, any questions on that? Any questions? Now, sometimes these distributions in the year of death do get missed by the beneficiary. Recall Debbie had talked a little earlier about missed RMDs and requesting that waiver, or now under Secure 2.0, the 50% excess accumulation penalty tax. Well, that could be waived by the beneficiary if they satisfy the RMD later and request the waiver. Secure 2.0 now is going to reduce that to a 25% tax and actually down to 10%. And as we discussed later, we're not sure what the IRS is going to do about the waiver that they've been pretty good about doing for IRA owners and beneficiaries, and whether or not they're simply going to assess the tax. So we'll have to wait and see, but the same rules are going to apply there. Okay, any questions on that? Satisfying the year of death RMD. Okay, on page 65, we've got distribution options where the IRA owner died on or after the required beginning date with a traditional IRA. So when we take a look at this, of course, let's start out with our eligible designated beneficiaries, and we'll start out with the spouse. They have all those options. They can take a lump sum. What they're more than likely going to do is probably transfer to their own IRA, or take a distribution and roll over to their own IRA or eligible plan. Or they could choose life expectancy payments. Well, since RMDs have already begun because they died on or after the RBD, if they choose life expectancy payments, those must begin by 12/31 of the year following death. And then we use the longest life expectancy, either the beneficiaries, spouse beneficiary's age in the year following death, or if that spouse beneficiary were older, the IRA owner's single life expectancy, which we look up that factor in the year they died, and for that year following death, subtract 1. And then we would use non-recalculation. If we were using the spouse's single life, the spouse then gets to use recalculation for theirs. If we use the decedents, we use non-recalculation. Now, what are they going to do? They're probably going to treat it as their own, because if it's in their own, they get that uniform lifetime factor for RMDs for their own calculation, which usually are going to be more favorable, resulting in smaller RMDs. Now, if it's an eligible designated beneficiary, that's a non-spouse. Well, they could choose lump sum, or they could begin life expectancy payments, which would begin in the year following death. Again, they can use their own life expectancy. If they're older, then we use the decedent single life expectancy in the year of death, reduced by 1. So again, it's the longer of the single life expectancy of each eligible designated beneficiary, which we would look up in the year following death. Each subsequent year, using non-recalculation, we subtract 1. If it's the decedent single life, we look up what their life expectancy was the year they died, reduce that by 1, and then each subsequent years, we're going to use non-recalculation and subtract 1. Okay, so for eligible designated beneficiaries, that's what we would do. Now, if it's the minor beneficiary choosing life expectancy, we would use the minor single life expectancy in the year following death. We're going to use non-recalculation, subtract 1 each year. Once they reach the age of majority under the proposed regulations, that's age 21, they switch to the 10-year rule and then have to deplete it within 10 calendar years. In other words, it would have to be totally distributed by the end of the year they reach age 31. So one of those special rules for the minor child of the decedent. Okay, if it's simply a designated beneficiary, well, they could take the lump sum, or they could take it under the 10-year rule. Under the 10-year rule, using that at least as rapidly rule, it does require single life expectancy payments using non-recalculation for the first 9 years, and then anything remaining in the 10th year would have to be totally distributed. If it's a non-person, they could take a lump sum, or for that non-person, we use the decedent's single life, which we look up in the year of death, and reduce by 1 for that first distribution year. And then each subsequent year, we'd be reducing 1 from that factor to pay out to the non-person beneficiary. So these are all the options for beneficiaries if they died on or after the required beginning date. Any questions on those options? Again, that's a good resource to have available if you need to explain those options. Okay, we've got an example here for beneficiary payments for death on or after January 1 of 2020. Florence was born April 27th, 1945, and died after her required beginning date on May 28th of 2023. Her husband, Walter, is the only primary beneficiary of the traditional IRA. So when would Walter have to begin his beneficiary payments? Well, he would have to begin those by 12/31 of 2024, the year following death. Since RMDs have already begun, those payments begin right away in the year following death. Questions on that? Any questions so far? Okay, page 67. Let's take a look at that. This is when we have a beneficiary name a beneficiary. How do we handle that? Well, this is a good little flow chart that we're going to go through so you have a good understanding. Keep this as a good reference. I'm not going to expect you to memorize this or learn all this. In fact, all these beneficiary options, you don't encounter it every day. So use these charts that we have for reference material and use those as a handy reference. So if we have a beneficiary that had an inherited IRA and then they die, what do? Well, we look to see, have they named a successor beneficiary? So if we do have a successor beneficiary named, then we can go through this flow chart. Did the account owner die on or after January 1 of 2020? No, they did not. So we're going to work to the left. Okay, then our next question is, did they die on or after? Did the beneficiary die on or after January 1 of 2020? In other words, under the new rules, if no, then the successor beneficiary would still distribute at least as rapidly as the original beneficiary. In other words, continue taking their life expectancy payments of the original beneficiary's life expectancy. If they did die after January 1 of 2020, then we have to know, did the account owner die before their required beginning date? If the account owner died before their required beginning date, then the successor beneficiary must deplete the account by the end of the 10th calendar year of the original beneficiary's death. So they have 10 years from when they inherit it from the beneficiary. If the account owner died on or after their required beginning date, then the successor beneficiary must continue the annual payments of the original beneficiary, and a total payout would then have to be made by the 10th anniversary of the original beneficiary's death. So that at least as rapidly rule comes into play here, where the successor would have to continue those. So that's if the IRA owner died in 2019 or earlier, and then the successor benefit or the original beneficiary died afterwards. Now, under the new rules, if the account owner died on or after January 1 of 2020, and we're under the rules under the Secure Act, then we look at, was the original beneficiary an eligible designated beneficiary? If they were not, simply a designated beneficiary, then the successor beneficiary, if the IRA owner died before the required beginning date, the successor beneficiary is subject to the original beneficiary's 10-year rule. If they had died on or after the required beginning date, then the successor beneficiary needs to continue the payments of the original beneficiary and what they were taking to deplete the account under their original beneficiary's 10-year rule. So some of those rules. Now, if the original beneficiary was an eligible designated beneficiary, okay, then they had the option of life expectancy payments. Well, if the account owner died before the required beginning date, then the successor beneficiary must deplete the account by the end of the 10th calendar year after the original beneficiary's death. So they have the 10-year rule that they could choose. If they died on or after the required beginning date with a traditional IRA, the successor beneficiary must continue annual payments taken by the original eligible designated beneficiary. So under the at least as rapidly rule, they would have to continue annual payments, and a total payout then would be required by 12/31 containing the 10th anniversary of the original beneficiary's death. So we have to continue those annual payments to deplete it. So these are some of the options of what happens if we have a successor beneficiary and the IRA owner dies. Okay. Questions on successor beneficiaries? Kind of complicated, isn't it? Keep these charts handy. They can be used as your reference. Okay, let's look at our example for successor beneficiary options on page 68. We've got Chris, who died in 2019 at age 62. He's named his brother Sam, age 68, as his beneficiary. Sam named his son Stephen as a successor beneficiary, and Sam died in 2022. Now, because Chris died before his required beginning date in 2019, and Sam died on or after January 1 of 2020, Stephen has until 12/31 of 2032, 10 years after Sam's death, to deplete that IRA. So this is just an example of following that flow chart for what the options would be then for Stephen. Okay, any questions? Any questions? Okay. We've got an exercise here for beneficiary options. So use your overview on page 55 there for a reference. We're going to go through these and see how well you do. So pull those out and let's take a look at these questions together. So we've got Alan, born May 20th of 1930 and died on June 18th of 2023. The primary beneficiaries of his traditional IRA are his wife, Catherine, his 66-year-old daughter, Sophie, and his favorite charity. So what options will the beneficiary receive? And we're going to assume separate accounting. So let's break this down and look at first his wife, Catherine. So what are Catherine's options? Chat that in once you can locate that for what Catherine has. You can abbreviate. You don't have to type all those words out. LE for life expectancy, LS for lump sum, T for transfer, DR for rollover, and 10 for 10-year rule. All of those work really well. So Catherine, his wife, what options does she have for her portion inheriting from Alan? What options? Amy, Mary say all. Okay, he died after the required beginning date. So the 10-year rule, I guess it could come into play, but really since life expectancy, or since RMDs have started, life expectancy payments have to continue even if they were under the 10-year rule. So life expectancy, lump sum transfer, and distributions and rollovers. So even though we have the 10-year rule, if you note on page 55, it says available if the IRA owner died before the required beginning date. But when they die on or after, as Alan did, really life expectancy distributions have to continue for the spouse if they don't treat it as their own. But I suspect Catherine would probably do that. Okay, how about Sophie, their 66-year-old daughter? What are Sophie's options? What are Sophie's options? What type of beneficiary is she? What are Sophie's options? Again, take a look at page 55 there for what those options would be. How about Sophie, the daughter? Alan's 66-year-old daughter. Amy and Mary, very good. He died after the required beginning date. Okay. Sophie has the 10-year rule, which would include annual payments, life expectancy, or lump sum. So under the at least as rapidly rule for Sophie with that 10-year rule, you still would have to take life expectancy payments each year. We didn't mark life expectancy because they do have to end at the 10th year. So she could not stretch those out over beyond the 10 years. So for Sophie, we would have the 10-year rule. How about his favorite charity? How about Alan's favorite charity? It's a non-person. What options does a non-person have? Remember, those are really just the old rules. What does the favorite charity have there? RMDs have started because he died after his required beginning date. He was born in 1930. Does anyone want to take a guess? What do you come up with there? If you look at non-person, we've got a traditional IRA owner who died, had already started RMDs because he was born in 1930. So for a non-person, we have lump sum or life expectancy payments for that non-person. So if you take a look at that, we have, let's pop that up here. Take a look at page 55. He died on that, so his favorite charity would have the lump sum. And then when we take a look at what do we have for his daughter, the lump sum or 10-year rule, but notice we have our triple where they have to take that at least as rapidly rule. And then for his wife, Catherine, she basically has all of those. Note that it says the 10-year rule is if they died before that. Okay, so let's look at page 70 and we'll wrap up this section here. On page 7, we got Greta, was born April 14th, 1990, died May 15th, 2023. Primary beneficiaries of her Roth are Peter, her husband, her daughter Eve, born October 17th, 2014. And there's a hint there, and her favorite charity. So what are Peter's options? First of all, the husband. What options does he have? And it's a Roth IRA, so we don't have any required beginning date to consider. What options does Peter, the husband, have? Again, refer to page 55 there. What options would Peter have? Yeah, 10-year rule, life expectancy payments, all of them. Lump sum, transfer, take a distribution, and roll over. Okay, how about Eve? She was born October 17th, 2024. What options would Eve have? She's born October 17th, 2014. What options? She would have the 10-year rule. They could choose, but she's a minor, so life expectancy payments under that special rule or lump sum. And then how about the favorite charity? Our non-person there for Greta. What would the favorite charity have? 5-year rule or lump sum? Very good. Questions on beneficiary options? Any questions? We covered an awful lot. There's a lot of information there. Any questions? Okay. IRA withholding requirements. Debbie, this will be your turn.
It is. You want to take a break now? Push your clock up and then I'll share my screen since my clock's not working after break. Perfect. Okay, we'll see you guys back in 10. Okay, well, welcome back, everybody. We are at our final section for today, which is our IRA withholding requirements as well as the new withholding forms. So before we get started with that, any questions that came up over break that you want to send out through chat to Jeff and I, or unmute your phones, you can certainly ask us that way as well. Okay, I'm not hearing anything. I'm not seeing anything. So we're going to go ahead and get started with our last section, learning objectives, on page 71. So what we want to do in this section is list the possible penalties for failing to withhold, as well as explain the withholding notice and the election requirements. We're going to discuss how withholding is reported and transmitted to the IRS, and then we'll also describe the withholding process for foreign withholding. So first and foremost, we're going to start out with the withholding definition on page 72. And really what withholding is a prepayment of income taxes. It's the ability of that individual to set money aside with the IRS to kind of offset what potentially is going to be due when they file their return. If they have overpaid and there's more in their withholding bucket, not just IRA money goes in there from a withholding perspective, but their employer withholding from their paycheck, for example, also goes in their withholding bucket. And if there's more in that bucket when they go to file their return, they're going to get that back as a refund. If it doesn't have enough in that withholding bucket to cover their tax liability for the year, then that's when they're going to have to pay in to the IRS. So it's credited against their tax liability. And again, they'll either get a refund if they've overpaid. If there's an underpayment, then they're going to go ahead and have to pay in. Withholding applies to everyone. It applies to IRA owners. It applies to IRA beneficiaries. No one is exempt from the actual withholding. Now, there are a few transactions we'll talk about that don't require withholding, but we have to offer it to all of our owners and beneficiaries in those taxable situations. And again, I'll bring up I think there's six pieces off the top of my head, transactional wise, where there's no withholding. It's not even an opportunity to do withholding. So we'll talk about that as well. If the individual is also subject to the 10% early distribution penalty tax, this is not the same as the withholding. Withholding at any point now, we'll talk about that in this section, is for non-periodic distributions, can be anywhere between 0 and 100% now. It used to be a minimum of 10%, and now effective this year, mandatorily going forward, it is any percentage. The only time that there's a mandatory percent withheld from an IRA distribution is if we don't have an election, and that would be 10%. And because that mandatory 10%, if no election is made, is the same amount percentage-wise as the early distribution penalty tax, some individuals get that confused and think they're connected, but it is completely separate from the early distribution penalty tax. They will handle that when they file their return and pay that accordingly at that time. So there's not anything that we can withhold to help prepay that early distribution penalty tax. Now, as we move on to page 73, we're going to take a look at our federal withholding requirements, and this comes from Internal Revenue Code section 3405. So we are required to offer withholding on all distributions that are subject to income tax. So remember, there's a handful of them that I'll talk about where there is no income tax, and so therefore there's no opportunity to withhold on those distributions. But on any distribution where there is potential for income taxes, we do have to offer the withholding. We also then have to provide a withholding notice to our IRA owners and to our beneficiaries to let them know of their opportunity to do a withholding. And we'll actually also look at the timing of those notices, depending on whether they're on a scheduled payment or if it's a one-time distribution in this section. If we've had withholding, we then as a responsibility of the organization, deposit that withholding amount with our federal depository. And we'll talk about the schedule for the depositing that as well, whether you're a semi-weekly depositor or a monthly depositor. And lastly, we have to, as an organization, report that withholding amount to the IRS. We will be reporting that on their 1099-Rs for each individual. We'll be reporting that on our 945 and our 945As. which is what we send to the IRS as far as our overall withholding for the month or for the by day if we're a semi-weekly depositor. And we'll be looking at the timing of the 945 and the 945A in this section as well. Now, if we don't do our withholding, there are penalties that can be faced. So we're going to take a look at what those penalties are on page 74. So you're going to have a chart there on page 74 of your guidebook that corresponds with the chart that I have up here on the screen. So the financial organization must pay the tax required to be withheld if we don't obtain a signed withholding waiver or an election to withhold. So the requirement is on the left-hand side of the chart that we withhold federal income tax or obtain a signed waiver from the withholding from that individual, whether it be an owner, whether it be a beneficiary. Otherwise, we as a financial organization must pay that tax that was required to be withheld. We are also required to keep records that are necessary to do the reporting with the IRS. So we want to make sure that we have that documentation. Otherwise, as a financial organization, we can be held liable for $50 for each IRA for which proper records were not kept. So particularly in an audit situation from the IRS, if we don't have that documentation that we can then provide the auditor, they can charge a $50 for each IRA penalty for not doing so. Third, we have a responsibility to notify our distribution recipients, and that could be our owners, that could be our beneficiaries, of their right to withhold as required. Now that's that withholding notice that we have to send out, and I'll take a look at the timing of that withholding notice in this section as well. That's dependent on, from a timing perspective, dependent on whether they're on a scheduled payment or whether it's a one-time only payment. However, the IRS can charge a $100 penalty to the financial organization for each failure. It does have a maximum penalty of $50,000 per calendar year. This used to be much smaller, and they changed it a couple of years back to $100 for each failure. I want to say it was 10 for each failure, but because I think we just had to add a zero to that. But at this point, it is $100 per failure. So again, it's something that they are looking at and definitely following up on if they're increasing that penalty fee. That would be my kind of opinion on that. And as far as depositing goes, we have a responsibility to, as I said before, deposit the withheld amount to our federal depository in a timely manner, whether we're semi-weekly, whether we're monthly filers, how that works. So there's penalties assessed to this, but it's not a flat rate. It's a percentage, and it's based on how late we are in submitting that information to our federal depository. So it's a 2% penalty on the amount if we are 1 to 5 days late. And it's a 5% penalty if we are now 6 to 15 days late. That penalty will increase to 10% if we are 16 or more days late. And if we are more than 10 days after the IRS has sent the organization a notice, that penalty increases to 15%. So there's not a dollar value attached to it, because the withholding amount could be different at any point in time, depending on what was done as far as distributions and those withholding elections. So if we don't deposit them in a timely fashion, that amount is going to be different for everybody, but it's going to be the same percentage for every organization based on how late they are. So that could change, obviously, with every missed depository. So make sure that you're doing that. The penalty is, as I said, the percentage of the amount that should have been deposited, which means it's going to be a different amount every single time. A failure to make a required deposit is going to affect all future deposits until everything has been corrected. So it's really important to make sure that those withholding deposits are done in a timely fashion. The IRA representative may not be the one who is submitting the information to their federal depository. That might be your accounts payable department. So it's important to work with whomever is submitting that to your federal depository to make sure that they're aware of what the rules are, the importance of following those rules, and depositing in a timely fashion to avoid any potential penalties and liability from the IRS to the financial organization. Now, as I mentioned, we have a responsibility to offer withholding on all distributions that are subject to income tax. But there are some distributions on page 75 where no withholding is there is not an opportunity to withhold. They're just distributions where there's never a withholding situation. So the first one that's listed is in a transfer. When someone is moving money from an IRA to another IRA of the same or similar type, so traditional to traditional, simple to simple, Roth to Roth, or possibly from a traditional to a simple, if the simple has met the 2-year rule, then when the check is payable to the other financial organization for benefit of Deborah Shipman, I don't have constructive receipt of the assets. And so in a transfer, I don't actually receive a distribution. There's nothing for me to potentially pay taxes on. So therefore, there's no withholding on transfers. So it's an automatic do not withhold scenario. The second one is in a recharacterization. Jeff talked to us earlier today about recharacterization, where they're moving that particular contribution, they're changing it from a traditional IRA contribution to a Roth IRA contribution. Now, keep in mind with the recharacterization, the net income attributable also needs to be calculated and moved along with the contribution to the other type of IRA. And it can go from a traditional to a Roth, or you could recharacterize a Roth contribution to a traditional. In either case, recharacterization is moving or changing that contribution from one account type to the other account type and treating it as if it had been that receiving account type contribution all along. Because of that, the owner doesn't receive any money. Remember, in a recharacterization, Jeff talked to us about how it has to be done directly. There's no owner access in that scenario. Again, therefore, there's no tax report, excuse me, not no tax reporting, but there's no tax liability, and therefore it's an automatic do not withhold. Our third one is in a direct rollover, when we're moving assets from either a traditional or a simple IRA, and again, that's if the simple IRA has met the 2-year rule, and we're doing that directly, check payable to the employer, over to the employer-sponsored retirement plan. In that case, again, because it's direct and there's no owner access, there's no tax liability, and therefore there's no withholding on that transaction either. The fourth one is a qualified charitable distribution. When someone is doing a qualified charitable distribution or QCD, they have to be 70 and a half or older. That age did not change to 72. And from what I have read so far in the Secure 2.0 information, I don't see anything changing that to 73. So while RMDs will not start until age 73, a qualified charitable distribution is allowable once they attain age 70 and a half. A qualified charitable distribution would be a distribution from an owner or from a beneficiary who is 70 and a half or older, and they are having that paid directly to a qualified charity. So the check would be payable to the charity. If it's a qualified charitable distribution, it's not taxable to them. It's a donation, if you will, to that charity, and therefore there's no withholding. So it's an automatic full amount that they request to be done as a qualified charitable distribution would in fact be the amount on the check. We also have an HSA funding distribution or health savings account funding distribution. Once in their lifetime, an owner of a traditional or a Roth IRA, because you can't do both, you can do one in a lifetime, can take money out of their traditional or Roth IRA up to the limit for their HSA contribution for that year. It does have to be a current year HSA contribution, but the money is going directly over from their IRA to their health savings account. Again, because it's being done directly and they're not receiving any of those assets, there's no tax liability on their end from that perspective. The IRS has no withholding on HSA funding distributions. While we're not talking about those today, if that you run into one of those are going to be reported in the standard distribution codes that you would use for the distribution. So as if it was in fact being paid to the client, you're going to still use that same reporting code. And the last one that we have is a qualified Roth distribution. So if the Roth IRA owner has met their 5-year rule and They have one of the 4 qualified reasons, which is death. So it's a payment to a beneficiary. They are 59 and a half or older. They are disabled under the Internal Revenue Code, or let's see, those are the only 3 that we could look at from a reporting perspective. That we coded as a Q. So if we know it's a code Q, then it's going to be a automatic qualified distribution, thus being tax-free, thus there's no withholding. The 4th qualified reason is first-time home buyer, but we do code that as an early distribution, and they do have to prove that to the IRS when they file their return. So we really only can report code Q on 3 of the 4 qualified reasons: age 59 and a half, disability, and death, payment to a beneficiary. So as an example, I personally have met my 5-year rule, but I don't have one of those 3 qualified reasons. So if I'm doing a distribution from my Roth IRA, you would have to offer me federal withholding. Now, if let's say I pass away, my beneficiary of my Roth IRA will inherit my 5-year rule. So they have met the 5-year rule on those Roth assets that they've inherited. And my beneficiary is doing a withdrawal due to my death as a beneficiary. And therefore, it's an automatic tax-free distribution for them. So we would not have to offer withholding, or we wouldn't offer withholding in that particular scenario. So these are the 6 reasons on page 75 where there is not a withholding opportunity, and it's an automatic do not withhold for any of those 6 distribution types. Questions on any of that before we take a look at the distribution from the forms perspective? Okay, so looking at page 76, sorry, the page number is wrong on the slide. So it is page 76 that we are looking at. Excuse me. Make note of that to get that updated. Okay. We have a responsibility as a financial organization to provide withholding notices when distributions are an aggregate of $200 or more per year. So we generally do that with every withdrawal. We offer the withholding notice on all of our withdrawal forms and scheduled payments. We set that up, and when they set up those payments, they fill out a form, and it has the withholding election on there as well. So we're providing those notices at that time. They have a responsibility to make an election. They can certainly waive their withholding election if they would like to. They can withhold any percentage on a non-periodic distribution, which is a payable on demand distribution, your IRA savings, your IRA certificates, your non-annuity types of IRAs. If we do not have an election on file and they do not make an election, we are required to withhold. So the IRS says, even though they can choose any percentage and that they can waive if they would like to waive, we have to withhold in the event that there is not going to be an election. We don't have one on file. For example, let's say I send in a letter to the organization and I say, hey, transfer $1,000 out of my IRA to my checking account, but I don't give you any withdrawal authorization, withholding authorization or information. Because my financial organization does not have an election on file for me already in regard to my withholding, they would have to mandatorily withhold on a non-periodic distribution that's going to be mandatorily withholding 10%. Now, if I make an election, that is going to be valid until it's revoked. That could be an election to waive, that could be an election to withhold a certain percentage. But once my election is in play, once I've made that, it is valid until it is in fact revoked. Now there is a difference, and you'll see a chart here in the middle of page 76 between periodic distributions and non-periodic distributions. So periodic distributions are annuity or similar type periodic payments, and they have a default withholding rate that is single with no allowances, and that is on the new W-4P. It's the modified W-4P form that the IRS updated in 2022 and then updated again for 23 information. They can on a periodic distribution, which again is an annuity or similar type periodic payment, they can waive the withholding through that election on the W-4P. A non-periodic distribution is on the new form W-4R. This was created in 2022 and it was optional for usage in 2022. It is mandatorily used in 2023. Now you can be using a substitute form. So we will take a look at a census's withdrawal authorization form, which is a substitute form in place of, let's say, the W-4R. I'll show you what that looks like. And it has to contain, the substitute has to contain the same language as the W-4R. So our withdrawal form as a result went from 3 pages to 5 pages because of the language that is required on there from the W-4R, because it has to mirror that. These are payable on demand accounts. A non-periodic distribution is an account that they can get access to at any point in time. This would be your IRA savings accounts, your IRA certificates. Even though your IRA certificate may be locked in for, let's say, 2 years, I could break the term of that certificate, even though I might have a penalty through the financial organization, and access my money within that time frame. So it's still considered a payable on demand account. Those are subject to a default 10% withholding. That's if I don't make an election. But if I do make an election, I can withhold anywhere between 0 and 100%. On the W-4R form or the acceptable substitute, there no longer is a do not withhold box. The IRS removed that from the W-4R. Actually, it shouldn't say removed it from the W-4R, but they didn't include it on the W-4R like we used to see it on the old W-4P. So to waive withholding through the new process on your substitute form or on the W-4R from the IRS, to waive, they would have to make an election of 0. It is exactly the same as do not withhold. There just is not an actual do not withhold box any longer that is offered to IRA owners or beneficiaries. But any percentage is okay. Now it has to be a whole percentage. It can't be a decimal point, but any percentage between 0 and 100, that's a whole number, is perfectly fine underneath the new rules. And again, those are effective beginning of this year mandatorily. In 2022, they were optional to be used. You could use the old rules or you could use the new rules. This year, you have to use the new rules. So as I mentioned, we now have a modified W-4P, which is a new form that's changed for just those annuity or similar periodic payments. And we have a new W-4R, which is for your payable on demand payments. So if we take a look at page 77 with these two forms, what was the old form? What was the new form? How does this move forward? Oh, question came in. The Walter Kluwer distribution forms do not use the W-4R yet. So what do you need to do for 2023 distributions using the old, I'm assuming, Kathy, you mean the old W-4P. What you would be doing for 2023 if your vendor forms do not have the new information on that, and I'm going to go ahead and have you skip for this answer to the question, skip ahead to page 79. This is what a censuses look like, and I will bring this section up. This looks just like the IRS version. I'll bring you the IRS version up in just a moment too. But you're going to use the IRS version. If your form doesn't have the new rules, like a censuses does here on page 79, you're going to go ahead and use the IRS version. So here's the 2023 W-4R from the IRS, and you can order those from the IRS if you need to. It's their order through irs.gov. You can go out to their website to order forms. And this is what that looks like. I'm just going to go ahead and make it a little bit bigger so that everybody can see it. And my eyes are getting a little older, but you'll notice that this is the 23 form. In the book, you will have a picture of an 80 and 81 of the 2022 versions, because that's what was available at the time that we finalized these guidebooks. But the 23 form has now been released. So that's what's available on the IRS's website. So you would use the 2023 W-4R for your non-periodic folks. You would use the W-4P for 2023 from the IRS's website for your non-periodic, excuse me, your periodic folks. Your non-periodics are the W-4Rs. If your forms provider has not updated their forms accordingly. So this is the W4R for your non-periodic payments for 2023. And you would just have the owners complete that. So again, your picture's on page 81 that corresponds to what I have up here on the screen. 81 is the 22 version. 80, what I have on the screen is the 23 version off of the IRS's website. You'll see that I'm just up here at the irs.gov. And I just did a search for W4R and then popped up the PDF for you to look at. So the owner's information, Kathy, is going to go here in part 1A, and 1B is their social. For non-periodic payments in this first bullet point, the default withholding rate is 10%. So if you don't have an election, you have to withhold 10. You can choose to have a different rate by entering the rate between 0 and 100%. And again, 0 is waived. And then generally you can't choose less than 10% for payments delivered outside of the United States and its territories. So I'll talk about that in this section as well. So on number 2 down here, you're going to complete this line. Sorry, it doesn't highlight really well. Complete this line if you would like a rate of withholding that is different than the default withholding rate. Remember that default rate is 10. So if I want something greater than 10 or less than 10, I have to complete part 2, because otherwise you got a default 10 anyway. The instructions are on page 2, which is, again, this is now 3 pages. So that's what's kind of lengthened our documents as well. And at the bottom of the first page is the marginal rate tables for that particular year. As I mentioned, it has to be a whole number and no decimals. So right in this box here is where that individual would go ahead and just type in they want 15% or they want 7%. But again, it can't be 7.2, it has to be 7 or 8. Okay, so if your vendor forms are not updated, then you want to go ahead and use these documents. A census's document on page 79 has been updated. If you do use the W4P for your periodic distributions, then you want to actually use the IRS version. We don't have a substitute for the W4P, but you can find that at irs.gov. For federal withholding for W4R, it has exactly the same language that you saw before. I can't highlight this. Excuse me. As soon as I did that, I knew it was going to click through. I can highlight it. I just have to get to my marker, I think. I'll just let it go. So here's that same language as the first bullet point on the W4R. And then here's the information exactly as it reads on number 2 in the W4R. And you'll notice here's the percentage. So on federal withholding, there's no more do not withhold. It would have to be 0%. State withholding, which Michigan has state withholding, you're going to follow that state rule as well. Do you need to go back to distributions done before 2023? You don't, because remember, it's valid until revoked. So if we go back to page 76, don't quote me, 76, the last bullet point on page 76, once the recipient makes a withholding election, it's valid until revoked. So if you have a withholding election already on file for Jeff, because he's done a distribution in the past, you can continue using that. You don't need to have him make a new election. If he wants to change his election, he can do so, and he can now choose less than 10% on the W4R or the acceptable substitute, but you don't have to have him reallocate the same percentage that he wanted. So you don't have to do anything going back for prior distributions. It's just moving forward. If they want to make a change, or if it's somebody new, you would want to have them make that election on either your acceptable substitute with the new rules or the IRS version of that form for that year. Oh, sorry, I misunderstood what you were saying. So the distributions were done in 2023, but prior to knowing this information. Am I understanding that question? Yes. Okay, perfect. I would recommend that you go back and talk to those owners and let them know that distributions need to have that withholding election. Was this somebody who never did a distribution before and we didn't mandatorily withhold? Or we just didn't offer the withholding? Because I think if we would have done a distribution, this is my thought process. If we would have done a distribution in 23, we would have either had an election on file, which is valid, and we would have used that election, no matter what it was. Or if it was a one-time withdrawal, we would have had them fill out your forms. You have old forms. That's where we're going with that, Kathy, right? You have the Walter Kluwer forms that don't have, so you use the old W4P. Kathy, did they elect waive or did they elect a percentage of 10 or greater? Or some both? Jeff, have you run into that?
I haven't run into it, but I know Walters Kluwer is usually on top of things. I'd reach out to them to see if they have a new withholding notice and form. I suspect they do. And maybe you just haven't gotten it at your bank yet, but I'd reach out because the reason I say that is I know a number of their consultants because Walters Kluwer's office is about 60 miles to the south of us.
Right.
And some of them used to work for our company way back when I started. So that's why I think reach out to them, see if they've updated those forms because I suspect they have.
And I would recommend if you use the old, and Jeff, let me know if you disagree with this, but I would say if you use the old, and Kathy, if I'm following correctly, you use the old W4P that had the minimum 10%, waive, what have you, on there this year, that you get a new election on the 2023 W4R or W4P accordingly, depending on which it applies to, for distributions moving forward. At least at that point, you could, if audited, prove to the IRS good faith attempt to just learn the information, got the new, election for the new rules moving forward. I can't guarantee that the IRS wouldn't look differently at that if there was an audit situation, but at least it shows good faith. That would be my take on that. Would you agree, Jeff, with that?
Yeah, I would agree. And anything, if they've made an election in the past, it's still valid until revoked.
Agreed.
Mm-hmm.
Kathy, does that help? Did I get all the way through that question? Okay, perfect. Thank you. Okay, so I'm going to bring us back to, I got to back up on my slides here. Bring us back to page 77. Okay, so new form is the W4R, that is called the withholding certificate for non-periodic payments and eligible rollover distributions. That's for your, what we call non-periodic distributions, your payable on demand accounts. So generally your IRA savings, your IRA certificates, your non-annuity and structured type payments. The form W4P has been updated to be just for those annuity and annuity or similar periodic payment types. So generally looking at your annuities, and that's called your withholding certificate for periodic pension and annuity payments. So that's done differently. That's got that different default withholding and so forth. In 2022, in the second paragraph on page 77, we could use the old rules or the new rules. And if we use the old rules, we could have used the old, which in that case was a 21 W4P in 2022. But in 2023, everything is mandatory effective January 1 of this year. And we have to be using those new rules or the acceptable substitutes if, again, your forms vendor uses an acceptable substitute like a census does for all of their withdrawal information. Withdrawal form, our RMD election, beneficiary election, all of that information has been updated, at least for us. So in that third paragraph, as I said, non-periodic distributions will use the W4R form. Periodic distributions will be using the non-periodics will be using the W4R form, and those will be anywhere from 0 to 100%. But do not withhold is not an option anymore, so they have to select 0% on that form, or again, acceptable substitute. And mandatorily withhold 10% if you do not have an election on file. Anything made prior in that last paragraph before the note, any election made prior is in effect until revoked. So they don't have to make a new election. They can certainly change, increase it, decrease it accordingly, but anything that they have before is still in effect. Now, if you have anyone who hasn't documented anything, keep in mind that default election rate is 10% on the W4R or the acceptable substitute for that. Now, looking at page 78, if you have electronic opportunities for that, so you have like withholding that can be done or withdrawals that can be done electronically, you have to offer that withholding in that same fashion electronically. That might not be done by you. It might be done more by your IT department, who sets that up on your system, on your online system. So if you have periodic distributions that would correspond with the W4P, the guidelines that can be referred to that is in IRS publication 15T as in Tom. If you have non-periodic distributions that would be using a W4R, but electronically instead of on paper, the guidelines for that can be found in IRS publication 15A as in Apple. So you can refer the IT folks to those publications to get those specifications that need to be followed for electronic opportunities that aren't being used via paper. Now, I gave you a sneak peek of page 79. So this is the census document. We did update that accordingly to the new rules. As I mentioned, if you use our forms and you have a annuity type payment, that will be done on the W4P, and you would actually use the W4P from the IRS's website. Federal withholding down here on the W4R matches exactly as I showed you from the W4R on the IRS's website. And then state withholding, which I'll talk about in just a moment, is also going to be then applicable based on that particular state. Michigan does have state withholding. Some states do, some states don't. And they are all different, pretty much. So we don't have anything specific listed here. You would just indicate the state, the percentage or the dollar amount, depending on the state option, or if an opportunity to waive withholding at the state level exists, they can mark that do not withhold state income tax box as well. Now, as I showed you on page 80, we have the 22 version of the W4P. This is the old version. Here's the IRS version for 2023. Again, our guidebooks were finalized before we had the 23 information, but it is now withholding for periodic pensions and annuity payments. So if you don't offer annuities or those similar structured type payments, you will never use the W4P, but otherwise they will just enter the information and follow the steps to figure out their withholding. And again, that is now lengthy in forms. This is going to be updated annually because it has the year on it. So this is going to be something that is going to update annually. Likewise for the W4R, which is on page 81, again, 22 version in your book, 23 here on the screen. Completing this or your acceptable substitute, but you'd fill in part 1, like I mentioned before, for a non-periodic payment, which is your payable on demand, your IRA savings, your certificates that you can access at any time, even if you're breaking the term, would fall here. And they can choose anything between 0 and 100%. Without making an election, they will end up with a 10% default rate. Question that came in, you sent out the federal withholding election notices in January and July. Do they need to contain the language on the W4R now? Yes, they do. So if you did already send your withholding notices in January with the old language, and I'm using the old language as you can withhold minimum 10%. Now they can withhold any percentage between 0 and 100. You would want to update that language and then send out that notice because the new rules did take effect January 1st of 2023. You haven't sent them yet. Then that's actually even better. You can update, then you don't have to do a second mailing and confuse anybody, but you would want to update that language to include the new information and that there's any election between 0 and 100%. Without an election, default will be 10%, something along those lines, and send that out. And we're going to talk about that schedule in just a moment as far as when you can send that, what those requirements are, but you would want to update that with the new W4R language. You can send the new W4R with that, the IRS version. or an acceptable substitute for your IRS notice if your forms provider has that. And again, Walter Coolers, you could check with them. A census has been updated from what I understand. I know our withdrawal forms have been, so I believe our IRS notice withholding, RMD notice, excuse me, has been updated as well. Excuse me, but you can update that language and send that out, but it does have to contain those new rules, or you would do a new mailing. So 80 and 81, those are the pictures that I showed you before. I'm just going to scooch right through these because we looked at that. I'm going to go back to the website here real quick. I talked about the marginal tax rates. So this is the 2023 version. So that's why I want to show you the IRS version. In your book on 81, you have the 22 version. So you'll notice that it has the marginal rates for 2022 on it. This is going to be updated annually because of that information being specific for that year. That also means that your forms vendor will be updating their withdrawal forms or anything that has the withholding information on it, because it has to contain the marginal rates for that particular year, and those could change, and those years are obviously going to change every year. Historically, a census and probably every other forms vendor out there has not had to update their withdrawal form because it's always been the same. But now that we have the marginal rate tables on there specific to that year, the IRS will be updating their W-4R in this case annually, and then we will have to be updating our withdrawal forms or any other forms that contain that information for withholding annually as well. So be prepared from the standpoint of whomever your forms vendor is. If you use those forms, that's going to be an annual update that you're going to need to make sure that you have access to, or that you're purchasing, depending on how you get your forms. If you don't have an acceptable substitute, you can use the IRS version on the IRS's website for that particular year, but it does have to be for that year. So you don't want to use 23 this time next year. You want to use the 24 version next year. So kind of be prepared for that. But they included now the marginal tax rate tables. So folks who are, let's say I'm a single filer and my income is between 58, it's above 58,575, but below 109,225, then I'm in the 24% tax bracket, that tax rate. So it helps me maybe gauge what I want my withholding to be. Because maybe I'm withholding more on other things, so I can offset this and I can still choose a lesser percentage or waive. Maybe I want to withhold 24%. And if I have more in my bucket, remember, I get it back as a refund. So this just kind of helps me gauge as an owner or a beneficiary what bracket I might be in. And again, those could change every year. So that's where this is going to be updated annually. Any questions on that before I look at the example on page 82? Okay. Before I do that, I do want to just mention, I know that Michigan has this going until 3 o'clock your time, which is in about 3 minutes. So if you do have to hop off, because I want to get through the information and not rush through that, we are continuing and we are still recording. Michigan will be sending out the recording to all of you who have registered for the session today. So if for some reason you do have to disconnect and hop off of the session today, you will get the recording and you can come back and finish watching this rest of this training for the rest of this particular section. So just to kind of give you a heads up, please do what you need to do, but we will continue to make sure that we get this done and questions answered for you. So on page 82, right? Did I convert the time right? I'm an hour behind. 2, 3. Yeah, that's right. Okay. Really bad at math. Conversion's not any different. So on page 82, Shanice is our owner. Okay, she is taking scheduled quarterly distributions from her traditional IRA in March, June, September, and December. Shanice elected to withhold 10% for federal income tax. And again, any percentage between 0 and 100 is fine. And she chose 10. In July, she came in and she took a $100 distribution. And at that time, she elected to waive withholding on that $100 distribution. Now, remember, your most recent election is on file is what's in effect until you revoke it. So she had 10% on file. She revoked 10% by choosing no withholding. So now no withholding is in effect. So how should withholding be handled on the next scheduled distribution if Shanice completes no additional paperwork? What should be done in September? Should the financial organization withhold 10% or do no withholding? What do you guys think through chat? She didn't complete any additional paperwork and waive withholding is on file right now. Correct. So in September, thanks you guys for responding. In September, she would then have no withholding on her distribution. That would be true for December, assuming that nothing is done between now and then that changes that information, making a new election. So what could the financial organization do to ensure that Shanice's distributions in September and December go back to 10% if that's what she wants to do? What could the financial organization do at that time after they've completed that withdrawal to waive the withholding? They could get a new election, send her a new notice, or get the election to do the withholding change. So thank you, she would complete a new withholding election for her distributions moving forward. That would bring her back to revoking the waive, and then now the 10% is back in effect. That's her most recent election. So when she comes in to do a distribution off schedule and she chooses a different percentage to withhold or different election to withhold than what she had previously withheld, you might want to then follow up and say, okay, after we've processed this distribution, because the withholding is different, we're going to go ahead and have you complete a new withholding election form that takes you back to 10%, which will then do 10% on your remaining scheduled distributions, unless you want to keep it at no withholding. So, I mean, that's really up to Shanice what she wants to do, but that's what I would recommend from that standpoint. Now, on page 83, if you have a foreign distribution, and I use the term loosely because we're going to talk about U.S. citizens living abroad as well. So I have a friend of mine, a sorority sister, who is living in Germany right now. She was in the Czech Republic teaching, and then she moved to Colombia for a couple of years and taught there. And now she's back into Germany and she's teaching there at the international school. And she has an IRA in Colorado where her parents live. And she wants a distribution that from her IRA, and she wants it sent to her in Germany. Now, she is a U.S. citizen, but we are sending that distribution to her at an address outside of the United States. So Jen cannot withhold, or excuse me, she cannot waive the withholding. It's mandatory that withholding is done. Mandatory on a non-periodic payment is going to be 10%. So Jen is going to have 10% automatically withheld. No matter what she wants to do, it has to be a mandatory 10%. She can choose more. But she can't choose waive. She can't choose that less than 10% that's now kind of in play for our U.S. citizens living in the United States, but it has to be a minimum of 10% or more if she wants. She cannot waive or choose less. If there is moving down on page 83, if there is a non-resident alien where there's a distribution, and this is most often I run into this situation with questions in regard to beneficiaries. The owners died, they have a beneficiary who is a foreign citizen of another country, and they're residing in that other country. What do we do about withholding? Well, non-resident aliens are subject to 30% withholding. The IRS can't just go and take their stuff like they can with those of us who actually reside in the United States. They can take your stuff. So this is a 30% withholding amount, unless they have a tax treaty rate that lowers that. Some tax treaty rates are 30% anyway. Some are going to be less. I've seen 15%, some are 0. You can see from the screenshot that I had on the slide or on the bottom of page 83, a portion of the tax treaty rate table. Now, this comes from the IRS's website. It's table 1. That's the easiest way to kind of search for it. The title is in the last paragraph above the picture on page 83 for you. It's the withholding tax rates of income other than personal service income under Chapter 3, Internal Revenue Code and income tax treaties. It's a very long title. Search for table 1. It seems to be the easiest way to find the table, but all the countries are out there. And in order to use a tax treaty rate, the individual, if it's a person, and the individual has to complete and provide you a W-8 BEN. Now, that's in the second paragraph on page 83. The W-8 BEN is the Certificate of Foreign Status for beneficial owners of the United States, for United States tax withholding. So that's if it's a human. That would get them then the lower tax treaty rate. But without the W-8 BEN being completed and signed by that individual, most likely again a beneficiary, you would have to withhold 30%. If it is an entity, in this case it would be a beneficiary for sure, but it would be an entity such as a charity or something along those lines, but it's a foreign charity. They're going to then, in order to do less than 30%, the tax treaty rate, if it's available, they would have to provide you with a completed and signed W-8 BENE. And that is the Certificate of Status of Beneficial Owner for United States Tax Withholding and Reporting Entities, which is why there's an E on the end of that. So either one of those two forms, depending on who you're dealing with, a human versus a non-human, could be completed to get a lower tax treaty rate. Canada, for example, all the way over here under column 15, under pensions and annuities, as 15. So with a Canadian citizen, for example, if they give you a completed W-8 BEN, that would drop them from 30% to 15%. Without a W-8 BEN for that Canadian citizen, you would have to withhold 30%. So just kind of looking at that information. What we have on page 84 is kind of a diagram of what we've just talked about to kind of follow along with that information. So is the recipient a US citizen or a resident alien? If they are a US citizen or a resident alien, is the distribution being delivered to the recipient's address, US residence address? And if the answer to that is yes, they can elect out of withholding. This is 99% of the time what you're going to run into. I come into your financial organization, I want to do a distribution, and I have an address in Wisconsin. Okay, Jeff has an address in Minnesota. So we're both going to be able to choose the election that we want, including waive any percentage between 0 and 100%. Now, Jen, my sorority sister who lives in Germany, okay, she is a US citizen, but we are not delivering it to a US address. We are delivering it to her address in Germany. So she may not elect out of withholding. She mandatorily will have 10% withheld. Again, she can have more if she wants, but nothing less, and she can't withhold, or excuse me, she can't waive. If you are, however, dealing with somebody who is not a US citizen or resident alien, have you received a W-8 BEN or W-8 BENE? If the answer is yes, you have received the W-8 BEN or W-8 BENE, then they can elect out of the mandatory 30%, and you can apply the treaty rate from that table. So that's where Canada would go down to 15%. If they have not provided you with a completed and signed W-8 BEN or W-8 BENE, they cannot elect out of the withholding for the tax treaty rate, and it would be 30%. So the diagram on page 84 really kind of outlines the information on page 83 in a visual format for you. Now, if we have withholding or if we have a foreign person from that perspective, so whether it's the tax treaty rate, whether it's the 30% mandatory because we don't have the W-8 BEN or W-8 BEN on file, then we have to do the reporting of this distribution too. And that distribution in the paragraph under the diagram on page 84 would be done on a 1042-S. It is not done on a 1099-R. I would have the 1099-R, but a foreign individual would be using the 1042-S. So you'll complete the 1042-S for those individuals, and that is their version of the 1099-R. Form 1042-S is filed even if there was a tax treaty rate that was 0. There are some countries where the tax treaty rate does drop them down to 0, for example. So Belgium is 0. So we don't have to withhold in that scenario if we have a W-8 BEN or BENE for a Belgian citizen or a Belgian charity. And we still have to do the 1042S. So making sure that you're doing that, even if that tax treaty rate drops to 0. Now, as far as the withholding notices go, this is something where we have to notify our owners of their right to withhold in a timely fashion. And this is going to take us to page 85. The withholding notice generally is done on individual distributions at the time that the distribution is being requested, because on your withdrawal form, most forms vendors have that withholding notice right on there. So I gave you an idea of what our form would look like on the withholding piece of it. And again, it's got the withholding information on it. Otherwise, you would be using the W4R, the W4P, in addition to your withdrawal authorization form if it doesn't have the withholding information on it. So kind of be aware of that. If you have somebody who's on a scheduled payment, then the timing of the withholding notice is going to be different based on when they're scheduled or how they're scheduled. If they are scheduled quarterly or more frequently, then you have to notify them before the first distribution each year. So they would get this once a year. They can get it more often is fine, but they can't get it less than that. Excuse me. And you'd be sending them the appropriate year's W4P or W4R or an acceptable substitute if you're using that from a forms provider. If they are on a scheduled payment that is less frequently than quarterly, so our semi-annual payments, excuse me, or our annual payments, then we would need to notify them before each distribution. So our annual folks, for example, would get this once a year. They can get it more often, but at a minimum, they have to receive it once a year prior to their first payment, no more than 6 months ahead of schedule, but early enough to make the change. And if they're not semi-weekly, I don't know anybody that's semi-weekly, but if they're semi-annually, so they're getting payments twice a year, you would need to send this before each distribution. So they'd be getting their notice twice a year. And again, you could use that year's W4P or W4R, whichever is appropriate, or the acceptable substitute from your forms provider. Again, keep in mind that with the less frequently than quarterly, it has to be no earlier than 6 months before the scheduled transaction, but early enough to allow them to make the change. That is, I think it was Kathy, that's what you're talking about, where you hadn't sent, we were talking about the question, you hadn't yet sent out your notices. You generally do that in January and July. So that's where this notice is coming, where you're sending it twice a year. You're catching those semi-annual folks. Annuals can get it once a year, or maybe they're getting it twice a year because more than once is okay. Same thing with your quarterlies and your more frequentlies. You only have to do it once a year before the first payment, but if they get it more often, that's okay. You just don't want to be doing it less. This goes back to if you are not notifying them correctly or timely, there is that penalty. And that was back on page 74. That's where this is a $100 penalty for each failure with a $50,000 per calendar year maximum. So if you're not notifying them of their right to withhold, then that penalty is what we're looking at. Question came in, is the US citizen and resident alien with an out of the country address, is that default withholding rate 10%? So in the example that I used with my sorority sister, Jen, who's living in Germany, she's a US citizen, but we're sending it to her German address. Minimum, if it's a non-periodic distribution, so it would normally use the W4R, that minimum is in fact 10%. If it is the W4P, because it's an annuity or a similarly structured payment, that would be based on the single. So that goes back to page 76 in that chart. The default withholding rate for the W4P would be single, no allowances. So 10%, yes, if it would otherwise use the W4R, that type of payment. If it's a W4P structure, then it would be the single, no allowances. So the example that I have is for the timing of this notice is on page 86. with Valley Financial, you're welcome. Valley Financial mails out withholding notices to recipients twice a year on the following schedule, kind of like Kathy does. She does it in January and July, but Valley Financial does it in December and June. Almost identical, it's just 1 month off from what's happening. So in December, the withholding notice that Valley Financial sends is mailed out for their annual scheduled payments in the first 6 months. And then all monthly, quarterly, and semi-annual distributions are caught at that point in time as well. Then in June, what Valley Financial does is they just send it out to their annual notices or scheduled in the second 6 months and their semi-annual distributions as well, because they're getting it again the second time. Now, if Valley Financial decides just to do everybody in December and everybody in June again, that's fine. They don't have to kind of cherry pick who needs to be in there. It's certainly less mailing if you don't include everybody all the time, but it might be easier from a standpoint of we just do all of our payments. But at a minimum, you have to notify them on that schedule. And again, choose whatever cycle you want. December and June is just an example. Kathy uses January and July, but make sure that you're following those rules. Questions on that up to that point? Excuse me. Okay. So the next thing that we're going to talk about is withholding and depositing the assets for your federal depository. How do you do that? How do you report that? Well, the first thing that you want to do on page 87 is you want to track the assets. So you want to establish a separate general ledger or GL that only holds the IRA withholding for the federal side. Now, Michigan does have state withholding, so I would recommend that you have a separate GL for your Michigan state withholding and not to combine them into the same general ledger. It's just a lot easier for tracking perspective to say this is your federal and this is your state. That way you have it kind of set aside, your tracking, and it's going to be much easier when you're trying to report that information to the federal government or to the state to have just that withholding in that general ledger for that particular type. You also, as a financial organization, then need to determine your deposit schedule, and your deposit schedule is going to determine on what's called a look back period. And for 2023, you're going to look back to what was done in 2021. So the look back period is always 2 years back. 24, you would look at 22. 25, you're going to look at what did you do in 23. So it's always going to be a 2-year look back period. It might change in a year because of what's happened. Most often, once you're on semi-weekly, you're going to stay on semi-weekly, and it likely won't ever go back to monthly. But you're always going to look at that look back period, which is 2 years prior. So for 2023, what your organization would do is look at what was the total tax that was reported on your 2021 IRS Form 945. Now, this might be done by your accounts payable department and not your IRA department. But it's good for you to know what those rules are, even if that's not something that you're specifically working on. One, you might get called in to assist on it. Two, you might want to make sure that it's being done correctly as well. Because again, there's penalties. Remember, if you're not doing this in a timely fashion, that 2%, 5%, 10%, 15% can get costly. And it's not going to be considered fixed until it's all brought up. So one missed thing kind of upsets the apple cart until you pick up all the apples. So it's important to kind of understand how this works. So looking back at the 2021 IRS Form 945, if your total tax reported was $50,000 or less, then for 2023, you are a monthly depositor for your schedule. So you would deposit your non-payroll withholding to your federal depository by the 15th day of the following month. So what you withhold in January, you deposit by February 15th. If on the 2021 945, your total tax reported in 21 was over $50,000, you are a semi-weekly depositor for 2023. And that means that you are going to deposit any amounts that were withheld on Wednesday, Thursday, and Friday with your federal depository by the following Wednesday. And anything that was withheld on Saturday, Sunday, Monday, and Tuesday will be then deposited to your federal depository by the following Friday. So it's basically 2 days every week is kind of, or semi-weekly. You're doing one on Wednesday, one on Friday. is what you're doing by the following. So what was withheld on these days, following Wednesday, what was held on these days, the following Friday. So you're kind of looking at that from a semi-weekly standpoint. It's going to happen more often than your monthly depositor, which is literally once a month in the following month, okay? Now, there is an exception to this, and that is underneath the chart on page 87. If your accumulated non-payroll withholding reaches $100,000 for any day, not week, not month, any day within a deposit period, then the financial organization has to deposit those withheld assets by the end of the next business day. And then thereafter, you're semi-weekly. So if you were monthly before, you're semi-weekly now if that happens. Highly doubt you're going to run into somebody withholding or a combination of withheld for non-payroll taxes to be $100,000 in a given day. But it clearly can happen because we have a rule about what to do should it happen. So be aware of that. So you're going to be then a semi-weekly for the rest of that year and the following year, regardless of your 945 reporting for the look back period. So just kind of be aware of that. Now, you are going to then deposit on the bottom of page 87, you are going to deposit the information, the dollars from your general ledger to your federal depository. And you're going to do that through the EFTPS or Electronic Federal Tax Payment System. Only financial organizations with aggregate deposits of less than $2,500 during a calendar year can deposit that manually. Otherwise, everybody's going to be using electronic depositing, and that's through that EFTPS program. Again, very possible that your accounts payable department is handling this, but not at all a bad idea if you're not involved to verify that it's one being done, who's doing it, and that it's being done correctly. Questions on that before I look at reporting to the IRS on the 945, 945A, or the 1042? Okay. So on page 88, we have sent our dollars electronically, more likely than not, through EFTPS to our federal depository, but we also have to follow up with reporting to the IRS. And for non-payroll withholding, that's going to be done on our 945 form. That's the IRS form that has to be sent to the IRS by January 31st. So the 2022 945 would be due by the end of this month to the IRS. If all of your deposits were made on time, you do get an extension all the way out to February 10th. You basically get 10 days, but you get an extension. So, I mean, it's one less thing to worry about in January, right? And that's going to be on your 945. If you are a semi-weekly depositor, then you will report all of your non-payroll withholding on the 945A, and that will be filed with your 945. So 945 and 945A for semi-weekly depositors, 945 only for your monthly depositors. And again, deadline, again, same thing, January 31st or bump to February 10th if all of your deposits were on time. Now, if you had any 1042S's that you had to complete, either because there was withholding of 30% or a different tax treaty rate, or the tax treaty rate was 0, so there was no withholding, you still have to do the 1042S's to those individuals, but you will also then have to do the 1042 to the IRS, and that's to report your non-resident alien withholding. That is due to the IRS by March 15th. So it's not right now, but you want to make sure that that is being done by the middle of March. So you have about 2 months, give or take at this point, little less than. Now, the last thing that I want to take a look at in this section, and we'll wrap it up for the day, is our state income tax withholding starting on page 89. So Michigan does have state income tax withholding requirement. We only have to follow the state withholding regulations if both of these 2 bullet points at the top of page 89 are true. The financial organization has a branch or an office in the state, which I know all of you have a branch or an office in Michigan. At least I'm taking a pretty good guess at that one right now. And the distribution recipient is required to file an income tax return in that state. In some states, it might be that they're a resident only. That's where Michigan falls. Maine, Massachusetts, Montana, Nebraska, and Oregon, and Wisconsin, and I live in Wisconsin. State withholding also applies to individuals who are required to file in that particular state. So state residency at this point for Michigan, and you want to follow those Michigan rules. If you have any shared branching services that are outside of the state of Michigan where they can perform an IRA transaction, then you want to follow what those state rules are, because it's as if you have a branch or an office in that particular state. Now, let's say that you don't have any shared branching service in Wisconsin, but you do have me as an IRA owner. Because both of those things are not true, you do not have a branch or an office in the state of Wisconsin, even though I am resident and required to file in the state of Wisconsin. The question is, do you have to offer me Wisconsin state withholding? The answer to that question is your legal counsel will need to make a decision. Does having me as an owner in the state of Wisconsin constitute you doing business in the state of Wisconsin? Do you have to follow the state of Wisconsin rules? So you will talk to your legal counsel to determine if outside of Michigan, you don't have any branches or offices, but you do have owners that are in states with state withholding requirements. Are you required to follow them? If so, you will then have a third general ledger for the state of Wisconsin, which probably just has me in it as the withholding. And then you will have to reconcile with the state of Wisconsin for just that general ledger withholding. You well, Michigan for Michigan, Wisconsin for Wisconsin, and federal for federal. Now, if you have an owner in Illinois who has a branch, excuse me, who has an IRA with you, Illinois does not have state withholding, so it's irrelevant. The answer is we don't do state withholding for Illinois. So if it's not shaded on page 89, you don't have to worry about state withholding. If it is shaded and you have owners in that state but no branch office, legal counsel, your legal counsel will make a determination based on those rules in state law. And if you do have a branch or an office outside of Michigan in one of those shaded states, you will need to follow those state rules. Questions on state withholding on that information up to that point? Each state is different, so it's not as simple as saying this is what you have to do. But keep in mind the rules on page 90 are kind of outlining what you need to follow. So again, some states, there are state withholding requirements. Some states don't have them. So you want to offer them when required. Some states have possible notices that you do have to send out, like the W4P, or excuse me, not W4P. North Carolina, for example, has an NC withholding form. So that would have to be sent out accordingly. So some states have that. Michigan has a W4P for Michigan that you need to follow. You want to deposit that withholding into that separate general ledger. Again, I recommend it be a separate general ledger from your federal withholding to keep everything straight from a depository standpoint and reporting standpoint. And then you have to report accordingly with that state or states if you have more than one state that you are withholding for. The state income tax withholding guide has been recently updated because we've had some changes. This Minnesota came on. So that's new. Jeff newly has withholding in his state where he didn't have that before, but Michigan is on there, you'll see, and you do also have that Michigan W4P that can be obtained from the Michigan Department of Treasury to complete for that piece. Every state is different, excuse me. So you can kind of take a look at those. The general rules are listed right up here. Some states are a percentage, like Michigan has a percentage. If you look down to Wisconsin, which is where I'm located, that is a specific amount. As long as it's at least $5 per payment, I can choose whatever amount I want. So they are different. Iowa, for example, if you have anybody where you're doing Iowa withholding, you can't disconnect federal and state. So if you choose federal, you're automatically going to be doing 5% for the state of Iowa. Whereas in Wisconsin, I can choose to do one or the other or both. So you can kind of take a look at that, and that's kind of how Michigan reads as well. Michigan's obviously a little bit longer because of the birth date range and how that one reads, but ultimately follow those rules. So that wraps up everything that Jeff and I have for today. And again, I appreciate you guys hanging out with me and Jeff a little bit longer to make sure that we got you all of that information. Advanced is packed full of information. So hopefully all of your questions have been answered, but if not, we want to welcome any questions that you would like to add into chat about anything we talked about today or didn't, or unmute your phone and ask those questions. So please feel free to take a moment to do that if you like.
Any questions? Now's your chance. Any questions on even things we didn't cover today? I always like to open it wide open for you.
Absolutely. You're welcome. Thanks for hanging out with us today. And yesterday, I know some people were on for 2 days.
Yep. Yeah, thank you, everyone. Hopefully this has been beneficial, and use those guidebooks for good reference, because we gave you a lot of information and material, and it should assist you in being able to assist your clients as well.
Absolutely. And I agree with you guys. It would be nice if account holders kind of knew what they were doing and had a course such as this where they could follow some of those rules, because a lot of that is on their shoulders. I think Jeff will agree with me. It's like we talk about what the rules are, but a lot of it is, hey, FYI, this is what they have to do in case they have questions. This is the IRS form to, direct them to. They put this on their 1040 and this is their responsibility, but they ask questions of you. So you kind of have to understand what all those rules are, even if it's not something that you specifically would be doing, but at least directing them to.
Yes.
Well, I'm not hearing anything or seeing anything, so I would just like take an opportunity to thank you for attending today and or yesterday as well. And Michigan bankers will be sending out a recording, link to the recording of this session for you. So if you need to go back through anything for any of the topics that we discussed today, you'll have that opportunity to do that. So thanks so much for attending.
Thank you, everyone.